Hi guys, so in this session we'll do two topics. We'll do FEMA and LLP, the two new additions but in marathon speed. So here what I'll do, I'll focus mainly on what are the things important for exam from these chapters which you have to at least minimum remember for exam. So I will take up provisions on random, take those concepts, we will make a note and proceed. Because if you look at the mock test papers, FEMA and LLP put together including MCQ, they are asking easily for 25 marks out of 100. MCQ and main questions easily, minimum was 25, I think they asked 25 to 30 marks. Okay. So first I will take LLP, do few concepts on a random basis and then proceed further. In LLP, now in LLP what is the main concept guys? We have multiple concepts, but the good thing is it has a lot of comparability with Companies Act and partnership. So here first, who can be partners in LLP? Who can be partners in LLP guys? It could be an individual or body corporate. So in LLP, an individual or body corporate can be a partner. Here I am discussing core provisions, bare minimum. Sir, I am planning to skip LLP. At least learn these few things. Okay. 1. Individual. Any individual can be partner except 3 people. Who are those 3? Except person who is of unsound mind. Unsound mind declared by a competent court. Next. Insolvent declared by court, adjudicated insolvent or insolvent for whom application is pending. Except these 3 people, anybody else can be partner in LLP. They have asked the question on this in mock test paper guys. Okay. Next, who is a body corporate? Basically it's LLP or company incorporated in India or outside India. So body corporate includes both of this. Companies Act only includes company incorporated in India. Here body corporate is a much wider definition. In simple, LLP and company incorporated in India or outside India. Body corporate does not include 2 things. What are the 2 things? Any cooperative society registered by a cooperative society act registered there, or corporate soul. Corporate soul is basically like, let's say, ambassadors, foreign ambassador in India, Indian ambassador outside there, or any corporation entity with just one person. Prime Minister is the only person who is the member of this entity. It's a corporation with one member. Are you following guys? But they won't test it in exam. Corporate soul, that's it. Corporate or corporate soul. So simple. In LLP, who can be partners guys? Individual or body corporate? Any individual other than unsound mind, but unsound mind declared unsound mind by a competent court. For example, you cannot tell I am unsound mind. No, you need to get a court certificate. Insolvent declared by competent court. Application which is pending for insolvency. Application pending for insolvency. LLP should have how many partners now? LLP should have minimum 2 partners. What about the maximum? Maximum is unlimited. Now, if this number of partners falls below 2, what should I do? Falls below 2. Whenever it falls below 2, that means it's becoming 1. That means you are no more a partnership, you are a sole proprietor. So within how many months? 6 months you have to rectify and add the number of partners to 2 or more. Otherwise your liability becomes unlimited from the date A when it falls, or after 6 months B. From point of A. From the time it falls below 2, from that point liability becomes unlimited. You have a grace period of 6 months to rectify, otherwise full period is unlimited liability. Are you guys following? Quick concepts. I will keep writing, just keep checking your notes or make a note. Next, financial year for an LLP. This provision is there both in section 129 of Companies Act and in LLP also we have financial year provision. First let me finish Companies Act. I will just revise again because we missed it over there. So financial year for a Companies Act. If a company is incorporated on 15th December 24, when does the year end? 31st March 25. That's it. No other option. If a company is incorporated on 2nd Jan 25, then financial year ends on 31st March 25 or 31st March 26. That means the cutoff date for company is any incorporation from 1st Jan of a financial year. If I incorporate even on 1st Jan, same year or next year. This provision is there even in LLP. In LLP financial year, the cutoff date is after 30th September. That means if you are incorporated on 30th September 24, financial year ends on 31st March 25. But if I am incorporated on 1/10/24, financial year ends on 31st March 25 or 31st March 26 at the option of the company. This is financial year for an LLP and company. Are you following, guys? Similarly, comparative provision. In company we have small company 2 subsection 85. LLP also we have small LLP. So small LLP and small company turnover, here paid up share capital, turnover. Same paid up share capital, turnover. Paid up share capital for company is up to 4 crores. Turnover is 40 crores. This 4 crores can go maximum up to 10 crores. Turnover can go maximum up to 100 crores. Do you remember this, guys? So small companies are the limits. Currently limits is 4 and 40, but this 4 can become 10 in the future, 40 can become 100 in the future. Similarly for small LLP, only limits are changing. Paid up share capital is 25 lakhs up to, and turnover is 40 lakhs. Small LLP, this 25 lakhs can go up to 5 crores. This can go up to how much? 50 crores. Okay, up to 50 crores. So this is small LLP, new addition. Small company they tested many times. Small LLP ketade kadiyadu. So straightforward 3-mark question could be small LLP. Paid up share capital up to 25 lakhs. Turnover up to 40. It's up to 25, guys. Up to 40. The 25 can become 5 crores. Turnover 40 can become up to 50 crores. So small company, small LLP. Financial year, its concept there in both the places. Are you following till here, guys? Next they are saying members of LLP, we can have maximum how many? Unlimited. So maximum unlimited means what happens now? If something goes wrong, who is liable? In a company, shareholders, board of directors. If something goes wrong in a company, who is liable? Board of directors. In LLP, we have partners. If something goes wrong, who's at fault? I can't go blame a specific partner. He will tell, ask him. So we need somebody who is, what to say, responsible. That responsible person is called a designated partner. Important, designated partner. Now designated partner, there should be minimum 2 designated partners. Who are these minimum 2 designated partners? It has to be individuals. Why individuals? I can't put company in jail. So only individuals it has to be. 2 individuals. So minimum 2 individuals. In that, at least one should be a resident in India in previous financial year. He should have stayed in India for at least minimum 120 days in the previous financial year. Then only he is a designated partner. Sir, now already you told me in starting, sir, LLP can have either individuals or body corporate. Let's say my LLP has, we'll take Mumbai Indians LLP. Now in Mumbai Indians LLP, let's say the individual is only Mukesh Ambani. The body corporate is, let's say, Reliance is the body corporate who is the partner in Mumbai Indians LLP. Now who will be designated partner? We need to have 2 individuals. So one is Mukesh Ambani. Who is the second designated partner? Reliance is not individual. So in that case, if body corporate is the only available leftover partner, they can't be a designated partner. So such a body corporate, Reliance will appoint some individual as a nominee of the body corporate who will become the designated partner. Let's say Reliance is appointing Hardik Pandya. Now Hardik Pandya will become the nominee of Reliance who is the designated partner. If something goes wrong, he will only be blamed. Whatever happens in the LLP. Are you following? Whatever happens in Mumbai Indians LLP, he will only be blamed. Nominee only will be blamed. Are you following, guys? Clear? Understanding? So what if I have already in Mumbai Indians LLP, Mukesh Ambani, Rohit Sharma and let's say Neeta Ambani. All three are, what is it, guys? Partners. All three are, already I have three individuals and I have Reliance. Now should I appoint nominee? Not needed. In Moonli I can appoint two. But if I want, you can appoint body corporate, also can appoint nominee. Are you following, guys? Now what, let's say after some time this designated partner might want to leave. So our designated partner we concluded was in this Mumbai Indians LLP we saw Mukesh Ambani and Hardik Pandya first, correct? Now Hardik Pandya wants to leave. He is no more the designated partner. He is fired. He is going to leave. Okay. Now if he is leaving, if a designated partner position is vacant, it has to be filled within 6 months. It has to be filled within 6 months is the minimum number of members, unlimited liability. If a designated partner is becoming vacant, you have to fill it within 30 days. Are you following? Now if you don't fill it within 30 days, who is liable? Now normally for an LLP, if something goes wrong, who is liable? Designated partner. Now in the designated partner vacant. So who should have filled other partners? So if designated partner position is not filled within 30 days, the only exception where all the other partners become liable. Are you guys following us? All the partners become liable. Are you understanding? These are provisions with respect to designated partner from section 7 to 9 of the LLP Act. 7, 8, 9 of the Act. 7 is designated partner, 8 is some filling 30 days, 9 is liability, all of that. Clear, guys?
Yes, sir.
Next, let's proceed. Are you all able to follow, guys?
Yes,
okay. Key points. Important. Designated partner fill 30 days left. Otherwise, all are liable. There is some penalty, guys. Some 10,000, all of that. Leave that. Okay. Next, let's proceed. We have concept of books of accounts for LLP. It comes under topic financial disclosures. Financial disclosures says in LLP should maintain books of accounts in double entry, but it can be in cash or accrual. This we already saw when I saw Companies Act. Next, filing of returns. LLP will file 2 returns on a yearly basis. They will file something called annual return and they file something called financial statement and solvency report. The section number is different, but it is similar to our Companies Act 92, similar to section 137. In 92, annual return should be filed within 60 days from date of AGM. Here LLP, annual return should be filed within the same 60 days to the ROC, but not from date of AGM. So from end of financial year. Are you guys following? End of financial year, within 60 days, I will file to ROC. This will be signed by a designated partner, will sign the annual return. Like 137, filing of FS and declaration of solvency. This declaration of solvency is new. What is that? Since I am a limited liability partnership, I have to declare that my assets are more than liabilities. I am solvent. This has to be filed. In Companies Act, it will be filed within
6 months.
Companies Act, it will be filed within 30 days from end of AGM. In section 137, filing of financial statement to ROC within 137. Here we will file it within 6 months from end of financial year to ROC. Sir, why they are giving 6 months here? Understand, AGM is already held after 6 months from end of financial year. After you already got 6 months time. That's why in Companies Act they give you only 30 days. In LLP AGM I need time to prepare FS and audit. So 6 months from end of financial year, again signed by DP with ROC. Are you following? I am doing a comparative study, guys. Companies Act you know, connecting with LLP. Are you following, guys? Clear? So annual return will be filed here within 60 days from end of financial year, signed by designated partner, file it with ROC. Financial statement and declaration of solvency, file within 6 months to the ROC from end of financial year. Both will be signed by designated partner. Are you following, guys? This is one procedure. Next, some more concepts. Let's say section number 30 and section number 31, section number 29. 3 concepts. I'm going in random, guys. These are enough, more than enough for LLP. Okay, section 30 talks about fraud. 31 talks about whistleblowing section, and 29 talks about partner by holding out. Section numbers LLP I will not revise, I will not insist. If you remember, it's fine. Companies Act only important. 148 sections you remember for 60 marks, it's important. Here hardly 10 marks, so few sections you remember, it's enough. Designated partner section 7, fraud section 30, or 4 section if you remember, if you are lucky that will come. Are you following guys? Fraud, simple. In LLP, if any partner does a fraud, then the LLP is liable. LLP is liable along with the partners. There is no limitation on liability. Partners are personally liable. The corporate will be lifted. Intention to defraud. Are you following guys? Next, what is whistleblowing? What is whistleblowing guys? Basically, for example, if you see in reality, there is this Snowden. There's a guy called Snowden. Okay, you might have heard about him, Snowden. You just Google later after the exams. You just put Edward Snowden, correct? Yeah. So Edward Snowden, if you put his interview, YouTube it will come. John Oliver took his interview. He's basically part of US defense, and he whistleblew and he escaped to Russia. He's now currently staying in Russia. That's what the last known report. What he told, the US defense has access to every device's camera. So even if my phone's camera is off, it's always on recording what they want. So US defense can see all of that, and so many privacy breaches he claimed against the US. So he whistleblew against the US and he went to Russia. Like this, so many things he told. Lot of security breach. Every message you send is read by people at the defense. All of that. So he made a lot of claims that nothing is secure. Okay. Now, whistleblower means somebody within the company. For example, if you take ILFS, Indian company, which is a listed company, currently which is share price is some 3 or 4 rupees. It was 180, 200. Company got into a scam and share price fell down because one article whistleblew and told all information about the company scam outside publicly. One CA article from the big four revealed it outside, intentionally or not. So if you do whistleblowing, the employee or the partner who gave information about the company, this is there even in Companies Act but not in our syllabus final. So such an employee or partner who gave information out should not be demoted. What is demoted? Opposite of promotion. Demoted. Should not be discharged, now should not be fired, should not be threatened, should not be harassed in any manner. He should be protected by the law. By the law which will protect them. Are you following guys? Satya is getting excited now. Next. At the same time, during investigation you will see in movies that accused will tell, like that, if you surrender and tell, I only did all the mistakes, we will be forgiven. No. Penalty 7 years imprisonment. Okay, stay for 5 years in jail. Like that. So during investigation, if a partner or employee pleads guilty and gives out more information for investigation which was helping in investigation, the court may consider and reduce his penalty. That only is whistleblowing. Are you guys following guys? Clear? Understanding? Are you understanding guys? So these people will be protected, or during investigation if you give more information, you will be, what is the penalty will be reduced. Are you guys following this whistleblowing section? These are all straightforward sections. They can ask what is whistleblowing in KEPA. Clear guys? So employee, partner, two things. Gave information, protect them. Investigation is against them, they reveal more information, reduce the penalty. Are you following guys? Okay, next section 29. Partner by holding out. Partner by holding out. Remember in foundation you studied partner by estoppel. That is the same concept over here. To give a simple example, let's say 3 of you together started a restaurant. Let's say Satya, Mohit and Shanmugam use pantame. Shreya, Mohit and Satya together started one restaurant called SMS restaurant. Okay, fine. Now in this restaurant, let's say they started. Now Kamesh came and he's saying, I also want to start restaurant in the future. Can I work here for 6 months and learn how restaurant is operating? Then these people told, you work but you should not eat. Then he told, okay fine. I will work, I will not eat. He worked for 6 months. When the customer get an order, cash vangi, he was doing all the orders. So whenever customers come, let's say Dhanush, everybody came for eating there. Then Kamesh acted like he is the partner, and these partners also agreed. Okay. Now later, suddenly one day, let's say Vignesh, who came regularly for the restaurant, he was getting married. So he ordered from this restaurant for catering and he gave some 2 lakhs advance. Kamesh took this money and ran away. Now, Vignesh came on the day of wedding, food is not there, all the guests got angry. Then after wedding, instead of going to honeymoon, first he came to SMS restaurant and he got angry. So he give the money. Now are these people liable, guys? Yes, because partner by holding out makes the firm liable, but here firm is not unlimited liability. To the extent of their share, they are liable. Are you guys following? Partner by holding out. Section 29. Are you guys following? Can we proceed, guys? Some more procedural points in this act. We are discussing a concept when a partner will leave the firm. When all partner can leave a firm, not be an outgoing partner. Example, partner insolvent. Next, insolvent declared by court or application pending. Next, unsound mind, again declared by court. Next, death is generally first one in the last death. The points when I get, guys, not what happens. Okay, death of partner. Next, LLP is dissolved, not full. I'm saying one partner is leaving. Next, voluntary or leaving. What is that? Resignation. So all the cases when partner leaves. Whenever a partner resigns, see, in death you can't expect him to give notice. Okay, but whenever partner resigns, within 30 days he has to intimate company. He has to intimate company first. He also has to intimate ROC. Okay. Now these people are outgoing partners in Partnership Act. But LLP does not call the word outgoing partner. Sunil Gavaskar is called what in India? Cricketer. What cricketer? Former, that same term. Former cricketer is used, the former partner. Are you following, guys? The act consciously use the word former partner. They don't use the word ex-partner. Meaning becomes different. So these partners are called former partner, guys. So these former partners will still be liable unless they give a notice of their leaving the firm is given to ROC either by the LLP or by the partner within 30 days. Are you following, guys? So this person is called former partner. He will still be liable until notice is given by him or the LLP to ROC within 30 days. Are you following? But let's say this is the point of exiting the firm, former partner. Until here, you are still liable. Until you are a former partner, you are still liable. Once you become a former partner, what are your rights, guys? Can you participate in management? No. Then what is your right? Right to receive your capital. Your rights are only 2 things. Right to receive capital and right to receive your share of profits on the date of resignation. So you have right to receive your share of capital, your share of profits. What the former partner cannot do, he cannot interfere in management. He cannot interfere in management. So former partner provisions. Who are all called as former partner? Partner who dies, death, insolvent, unsound mind, resignation. If you resign, give notice within 30 days. Now this former partner cannot interfere in management, but he can get his claim of capital, can get his claim of profits. He is still liable for all acts done until the date of his resignation or death, whatever. And this former partner should give a notice anyway to company, and this notice should be given to ROC by LLP or partner within 30 days. Are you guys following? Clear? This is with regarding to former partner provisions. Next, whenever partner changes his name or changes his address, he has to intimate that to LLP within 15 days. Whenever partner changes name or address, he will intimate LLP within 15 days. LLP, if LLP has any change of partners, if LLP also changes along with these changes plus these, they will intimate ROC within 30 days. ROC will make a note. Are you following? If the partner believes that the LLP is not going to intimate ROC, partner can directly intimate the ROC. There is no time limit for you will intimate ROC. ROC will now cross check with LLP and wait for how many days? 15 days. They will cross check and wait for 15 days. Are you following, Rajaram? Correct? Okay. Then are you getting it, guys? Again, this is some procedures following, guys, for LLP. Next. Everybody clear with this, guys? Change of name, address, inform LLP in 15 days, LLP to ROC in 30 days. If they don't inform, you inform ROC, they will cross check and wait for 15 days. Clear? This 15 days, can you check it's correct once? Okay.
Signed by one designated one.
The filing, yeah, of course. Every filing, simple. Every filing to ROC will be signed by one designated partner in all filings. Okay. Next. Are you following, guys? Clear? Any doubts still here? These are all LLP provisions. So far, what I have discussed only has come in the latest mock test papers and RTP, and this only is the foundation syllabus. We also have some new concepts in Inter, section 32 and 33 added in LLP in Inter, known as contributions. Let me explain. In company, we have something called guarantee company. A shareholder will give guarantee to a company at the time of company's winding up. We studied preliminary guarantee company with without share capital. Yes. Like that for an LLP, sometimes based on the LLP agreement, the partner can give some contribution to the LLP. Contribution can be in any form of money. It could be assets in any form, tangible, intangible. It could be any property which is movable or immovable property, any form. They give in the book of property, cash, money, movable, immovable, tangible, intangible. I can promise based on the agreement to make some contribution to the LLP. When I need in the future, when LLP needs money, I will make contribution, or I have already made the contribution. Are you following? Looking at this contribution, if any third party enters into any agreement with the LLP and the LLP does not make the payment, if LLP does not make the payment, then this contribution can be used to make the payment to the third party from that partner. Are you guys following? This is the mainly for protection. So if third party entered into agreement based on the obligation, the word they use is based on the obligation which is there for partner to LLP in the form of contribution, as a security I use money, third party entered into a contract. Now if LLP is not paying, I can make the partner contribute whatever he promised in the LLP agreement. Are you following? After entering into contract, if the partner and LLP come to a compromise, agree among themselves, no need to contribute. Now will third party lose his rights? No. I am repeating, if the partner and LLP agree, come to a compromise that no need to contribute. Now will third party lose the right? No. Third party can still claim his money. Are you guys following, guys? Clear? This is with respect to contributions, section 32 and 33. Next, some more new additions. They have added something called compromise and arrangement, amalgamation of LLP. I'll tell you the core points over here. Simple core points. Bookla 4 page potruppa. Compromise, arrangement and amalgamation of LLP. Are you following, guys? Compromise and arrangement says between the LLP and its partners, between the LLP and creditors, what is compromise? Sanda compromise, correct? Some kind of a settlement. It's like internal reconstruction. If you remember in accounts, they will agree at a settlement, you pay so much, don't pay so much, correct? So LLP and partners and creditors can make a compromise among themselves. This compromise arrangement is there in even in Companies Act, but not in our syllabus. Now what is the section saying? Follow this. Even if you are learning first thing, very easy, dead easy it is. No, follow. For making such compromise or arrangement, the LLP has to reach out to the tribunal. LLP will reach out to whom, guys? Tribunal, by giving some attachments. It's a huge section. In syllabus, in the book itself, they only gave teaser. So you will learn only teaser provisions. Teaser a little bit they give. So what are the attachments? So you will attach financial statements, audited financial statements of the company, and you will also attach
Pending investigation.
if there is any pending investigation against the company, because you want a compromise. Investigation that also I will know. Are you following? Tribunal will pass an order for compromise. Now this order will be passed. You can make application only if you are doing compromise with creditors or partners, 3/4 of value of them agree by passing a resolution. Are you following? Only if 3/4 of value of the respective creditors or partners pass a resolution, then only you can apply to tribunal. There is like how you pass special resolution for members. Here 3/4 of value should pass a resolution. Then you can apply to tribunal. Financial statement and pending investigation order will be passed. What happens after order? That's it. The compromise arrangement will take place. Are you guys following? Clear? That's it. This is one new concept added. What to remember for exam? 3/4 of value to resolution you have to pass before you go to tribunal. Tribunal attachment FS audited pending investigation. Order will be passed for compromise or arrangement. Sometimes they will pass order for amalgamation of LLP. Amalgamation of LLP. What is amalgamation? Whatever you know in accounts, two companies amalgamation, that same amalgamation is applicable here. Here they gave a statement which let's see if you understand this or not. They said that transfer as LLPs assets and liabilities will now become transferee LLPs assets and. Are you guys aware of this statement, guys? In the mind they explain what is amalgamation, one page in book, same as what you study in accounts. What is the key point to remember here? LLP cannot amalgamate with a company. LLP can't amalgamate with a company. Either convert the LLP to company amalgamation, or convert the company to LLP amalgamation. You can't do cross amalgamation over here. Are you following? Cross breeding not allowed. Okay, fine. Following, guys. Can we proceed further? Next, I'm going to look at some more new concepts in intro. We are going to finish, guys. 15 more minutes. LLP will get over. Next, they are saying if the ROC wants, we are discussing enquiry provisions. If ROC wants, ROC can enquire any information with the LLP or the partner, any information, whatever they want for any investigation, anything. If the partner is not cooperating, let's say partner is Kamesh, partner is not cooperating, he say I will not reply, I am busy. Now what the ROC will do? Partner will tell me police up. So ROC will summon him in front of a public officer who is a police. No, he's saying station. I will not come to the. He is not cooperating. Even when you summon with a public officer, then what happens for Kamesh? Penalty is there. There is one penalty, guys. Are you following? Like this, they give some provisions. If I want to inquire, first I will ask partner information. He's not giving now, I will summon him in front of public office. Aduku reply pallana penalty. Are you following, guys? That's it. Summoning a partner. Are you following? Next we have one more thing called compounding of offense. Compounding of offense. What is compounding of offense? What do you mean by compounding of offense? What is compounding? This is similar to section 87, rectification, condonation of delay. I made a mistake. There is a penalty. So you want to request them. So the LLP or the partner on whom there is a, let's take example. We'll take example of whom, guys? New example, just fast. Where is Snehan? Okay, Snehan. Okay. Snehan, guys, follow. Now, Snehan is the designated partner of LLP. Now, this Snehan has not even filed anything. He has not filed annual return. He has not filed accounts, not filed solvency, not filed anything. Now, there is already a lot of penalty that he has to pay. Suddenly one day he woke up and told, from now I am going to follow all the laws. He after watching some YouTube motivation video. So now he reaches out to ROC saying, please reduce my offense. Now I don't want what to say. I will pay or discount panni kodu. Okay. ROC will tell, I have to go to regional director. They will go to regional director. Regional director can pass an order that, okay, I will compound the offense. This is provision saying, directly this provision is legally allowing you to collect suitcase. I will compound the offense, but I will reduce the penalty. For example, let's say penalty for an offense is 5k to 25,000. They told Snehan to pay 20,000. Snehan is coming and requesting, ayo, I can't pay so much, please help me out. Then RD will reduce the offense after collecting a reasonable sum. Opener சொல்றான் காசு வாங்கணும்னு சொல்லி. Reasonable sum, but that reasonable sum should be a minimum. What is the minimum penalty he has to pay? And it should be in the range of minimum to maximum penalty payable. Are you following? Hello, are you understanding, guys? So LLP will go to ROC. ROC will ask RD. RD will tell, okay, at least pay a reasonable sum. Such a reasonable sum will be in the range of minimum to maximum payable. The minute RD passes the order, you have to intimate that the particular partner will intimate ROC within 7 days. Okay, I got the order, compound it, so you also leave me. Are you following? Then this got over. Again next month, Snehan went back to how he was before. He didn't file. Again penalty notice came. Again is going ROC, please. Compound. I saw a video part 2 in this today only. Okay, please compound it. Now ROC is saying, I will again go to RD. RD is saying, sorry, not possible. Compounding of offense can happen only once in 3 years. That means, in other words, not once in 3 years. The wordings they use is second offense within 3 years cannot be compounded. Second offense within 3 years cannot be compounded. What they are saying, what they are trying to communicate, you can do mistake once in life. Then we will not compound that offense. Are you following, guys? They are trying to teach us some life lesson also. The maker of this LLP Act in 2008. Following, guys? Pasana purida? Following, guys? Clear? LLP or partner go to ROC. RD will reasonable some minimum to maximum, but no second offense compounded. If they compound, I will intimate ROC within 7 days. These are all procedures not tested in MTP, not tested in RTP. Are you following, guys? But I am explaining, okay, if it comes, we will be ready with the key provisions. Clear till here, guys? Fine. Can we proceed further? Last 3 concepts. With that I will close LLP. I am going to take liability of LLP, incorporation procedure under LLP, and then winding up by tribunal. Examiner's previous favorite question, null syllabus. These 3 concepts if I take, it will get over. Liability section 25 to 27, incorporation process is the full procedure including name procedures etc. Winding up by tribunal. Last 3 concepts, let's say roughly 5 to 10 minutes each, and then we will wind up with LLP. Winding up by tribunal, they are saying LLP can be wound up by the tribunal if the following things take place. Are you guys following? Hello? Yes. What is the first thing? They are saying if the number of members falls below 2, most of the points are repetitive here. So if the number of members falls less than 2 for more than 6 months and they have not yet rectified, then the tribunal may order for winding up. These are the cases where tribunal by themselves will order for winding up. Are you following, guys? This straightforward question, previous attempt they used to ask, when LLP will be wound up by tribunal, what are the points? Are you following, guys? Next point, annual return or that financial statement and declaration of solvency is not filed for 5 consecutive years. 5 consecutive years you didn't file annual return or financial statement with declaration with solvency. Are you guys able to follow? Next, LLP is in continuous losses. Full I am in losses, I am not able to pay. That means your limited liability is being questioned. If you are still in losses, more people will be affected. Better you shut down now. Next. Unable to pay its debts. Again, unable to pay its debt now, liability is more than asset. Point C tells you are now getting to a stage where you can't pay your debts. Point 4 is saying you are actually not able to pay your debts. So number of members falls below 2. Then annual return or FS not filed for consecutive 5 years. Continuous losses, unable to pay its debts. If these 4 cases happen, tribunal may order for winding up. Are you following? Next. If LLP has acted against interest and against integrity and sovereignty of India or against the security of state of public. What they are trying to say, basically you are doing some anti-India movements, some terrorist activities, contributing to Taliban, like that. If you do any kind of acts, anything against India, then LLP will be asked to wound up. Are you following? Kamesh Purida? Okay, fine. Point F is the last point, which is saying LLP. Okay, one more, then G will write. One more point is that any other reason which is just and equitable. Any other reason which is just and equitable, if the tribunal feels, they will order for winding up. Example of just and equitable. LLP is selling, let's say, drink this water, you will never fall sick. They are doing fake marketing and selling products. This other movie Climax. Like that, if LLP is doing, if you watch the movie, you'll understand. Otherwise, leave it, guys. Let's say you are selling water, saying the water now it comes from Himalayas. Either Kursana, you will become pure, guys. And my some fake water, enga fill pandran, tablet fill panni vikram. And my if you do some acts, if they feel just and equitable, they will order for winding up. Are you following, guys? Next, last one. These 6 cases are when tribunal will order for winding up. Are you following, guys? The last point is LLP itself decides to wind up. LLP itself decides to wind up. In all these cases, LLP will be wound up. These points you have to remember, guys. Straightforward 5 mark question kepa. Sir, example latest ana sir ketom. LL idu kekala. In the MTP la enna ketirukana L idu ketana MTP 2 la ketana. Yeah, reveal panninga question. They are going to write in some time. Okay. I acted as if I didn't know. You guys reveal the question. Some students are here are going to write mock test 2 question. Okay. One question, one LLP they asked. What they asked? They asked, LLP is a corporate form of organization having flexibility of partnership and company. What is it? LLP has separate legal entity. All of this. Are you following, guys? Those students are going to write exam day after. You just ignore this. Oh, already saw. Okay. No problem. This main exam saw in the use. Okay. Are you following, guys? Clear? Hello? Understanding? Shreya, are you following? I will change the question paper, guys. Don't worry. Day after the exam, I will change it. Others ignore it, guys. Those who are watching recording, not for you. Okay. Fine. We are done with this winding up. Next 2 concepts. Liability of LLP 25, 26, 27. Are you all with me, guys? Hello? Important, guys. Follow. In this 1 hour of LLP, you see and make note of all these points. I can guarantee you 15 marks will come from here. Okay. You clap after it comes. Okay. If it comes. Okay. Fine. Now, follow, guys. Section 25. Do you know a concept called mutual agency? In partnership, one partner is the agent of another partner. Sir, I don't understand, sir. Let me explain. Now, let's take our LLP. Mumbai Indians LLP has 3 partners. Mukesh Ambani, Hardik Pandya, Rohit Sharma this time. Okay. 3 partners, Mukesh Ambani, Hardik Pandya and Rohit Sharma. Assume for a moment it's not LLP. Now, Hardik Pandya went and took a loan. He did not repay the loan. Who is liable? full firm, and all the other partners are jointly and severally liable if it is a partnership. That is the concept of mutual agency. One partner's act makes the other partner liable. That concept is not there in LLP. In LLP, if Hardik Pandya goes and takes a loan, only he is liable. Other limited liability partnership. So mutual agency is not there, but partner is the agent of LLP. LLP is liable for that loan to the extent of their share what Hardik Pandya has. Are you following, guys? This is 25. Next, 26 and 27, we are talking about liability of LLP. Let me give an example. Now, let's say Mumbai Indians team has a BMW car. Okay. Where they told this car should be used only by the captain. Okay. Now, Hardik Pandya took the car. Let's say he went on the car and he crashed into Nita Ambani. Okay. Fine. Guys, follow the example. We are discussing Mumbai Indians LLP, where Mumbai Indians LLP is saying you can only use BMW car by the captain only can use. Hardik Pandya took the car, went and crashed into Nita Ambani. Now, loss happened, car got damaged. Who has to bear this loss? Hardik Pandya or LLP? LLP has given authority to the partner. So partner has done a wrongful act, not intentionally, by mistake. So LLP will bear the loss. So LLP is liable if partner does an act wrongfully or omission, and he has what, guys? Authority to do the act. Are you following? Same example. This time BMW car who took? Instead of Hardik Pandya, Rohit Sharma took the car. Now he is not the captain, so he can't take the car, but he took the car. He went and crashed into Nita Ambani. Example only, guys. Any Mumbai Indians example solra. Okay. Fine. Now, in this case, who is liable? Only Rohit Sharma is liable. Here LLP is not liable if partner does any act for which he is having no authority. Here they are saying, key point, it does not matter if the third party, Nita Ambani, knows about this or not, or even if the partner himself knows, if he is not having authority, that's it. Firm is not liable. Are you following, guys? Clear? Now, when is the partner liable? Partner is liable if he does any act by himself where he has the authority. In this case, LLP and Hardik Pandya and others will share the loss. Are you following, guys? Liable and not liable. This is section 25 to 27. Are you following? Clear? Easier. Liable, not liable. This also we discussed in class. Hello, are you understanding, guys? This is LLP. 26 is liability of LLP. What is 27? Liability of partner. Correct? Liability of 27. 28. Liability of them. 27 is liability of this 26. Fine. Sorry, small change. 26. Mutual. If those who made note, just change it, guys. 26. Why we did this? If you write wrong section numbers in exam, what will happen? You will lose marks. So you should not do like this in exam. Okay. Section 26 is mutual agency. 27 is liability of LLP is 27. 28 is liability of partner. When is partner liable? When he does any wrongful act within his authority, whether intentional or not, within his authority, if he does any act, of course he is going to be liable. Along with the LLP. LLP also will be liable along with the partner. For example, Hardik Pandya took the car and crashed. Only firm is liable. I am also liable. Both of us will share that loss in whatever ratio we have. Are you following, guys? Clear? This is section 28. This is liability of LLP, partner, mutual agency. Clear, guys? Last concept in LLP. With this we will wind up. Incorporation of LLP. How to incorporate LLP? So we will wind up. Okay. LLP can be started by two or more partners or designated partners. Minimum I should have two designated partners. Step 1. These guys should get DSC and DPIN, and then they have to apply to whom? ROC. No, they have to reserve the name first. They have to reserve. This reservation of name is section 15(2). I'll come to the name provisions in the ending, guys. That is important. We have some amendments also over there. Once you reserve the name will be reserved for you for how many days? 3 months. In Companies Act, let's do a comparative Companies Act provision. In Companies Act, name will be reserved for 20 days for a new company. Existing company, name will be reserved for 60 days. Do you remember this, guys? Hello, do you remember this? New company name is reserved for 20 days in Companies Act. Existing company name is reserved for 60 days. In LLP, name is reserved for 3 months. Are you following? Then by the time this 3 months gets over, you have to file electronically E-form 2 with ROC. This E-form 2 will contain 2 things. One, detail with something called incorporation document. What is and one statement. So I'll again repeat. The 2 or more partners or DPs will get DSC or DPIN. They will reserve name. Name is reserved for 3 months. In the 3 months gap, I will file E-form 2 with ROC, where we will have incorporation document and statement. Incorporation document is simple, guys. Name and address of whom? Partner, designated partners, LLP. Name, address of partner, DPN. Write it multiple points. Then, what business I am going to do? Proposed business of LLP. I am going to deal in drugs. No, they will not give it. The business you have to pick, guys. Are you following? Then once you do this, you will get there. And you have to use statement. What statement? Are they same like Companies Act Incorporation? CA, CS, CMA or an advocate will sign that all information is true and fair and we are following the act, and it should also be signed by other next designated partner. So from externally CA, CS, CMA advocate will sign everything is true and fair and act. Internally designated partner will sign, one designated partner will sign that everything is true and fair. Are you following? Once you file all of this, the ROC will issue, they will give you a new certificate of incorporation by allotting a LLP IN to you within 14 days. They will reply to you. 30 days. 30 or 14? 1 second. 14 or 13? Check the book once. Check the book, make the correction if it's something else. Check the book once. They will reply within 14 or 30 days. 30. I'll tell you next. I'll tell you where 30 comes, guys. 14. I'll tell you where 30 comes. Guys, once certificate of incorporation is issued, you have to file LLP agreement to ROC. The draft LLP agreement should be filed within 30 days. Is it clear now, guys? Okay. Let me run through the entire procedure. They might not ask the whole procedure, but any point will be coming in maybe MCQ. So 2 or more partners or DPs will get DSC and DPIN and reserve the name for 3 months. Once they reserve the name for 3 months, they will file E-form 2 to ROC, which has 2 contains incorporation document and statement. Incorporation document, name, address of partner, DP, LLP and what business, proposed business, file it, and statement, CA, CS, CMA or advocate and DP saying everything is true and fair, file it with ROC. They will reply within 14 days giving a new certificate of incorporation. After that, within 30 days, you will file draft LLP agreement with ROC. The minute certificate of incorporation is given, it leads to section 14. In Companies Act, it's section 9. Effect of registration. What is effect of registration? LLP is now separate legal entity. LLP can buy assets. LLP can sell assets. LLP can sue. LLP can be sued. Do you remember these points, guys? That is effect of registration. Are they copy paste points? Companies Act section 9. LLP section 14. Are you following, guys? Clear? Understanding? Lakshmi following? No. Can we proceed, guys? Last few concepts regarding name. Name once reserved is reserved for 3 months. Such a name, this provision what I am discussing here is ditto copy paste from Companies Act. Only difference is reservation is 3 months, there it is 20 days or 60 days. Now once name is reserved, it should not be undesirable in opinion of central government. You cannot tell anti-India LLP, India down LLP. These kind of LLP names are not allowed. Undesirable in name of central government. Some political party XXX down LLP. All these are not allowed. Okay. Next, the name also should not be identical or similar to any other existing LLP, company, trademark, whether registered or not. Application is pending. Application is pending. Are you following, guys? Here what they removed, earlier it used to be there that the name should not be identical to a partnership, but the amendment has removed this. That means name can be identical to an existing partnership. They are trying to promote or ask this partnership to convert to LLPs. Are you guys following? Clear? Identical and similar. Now, for example, if I have Bata, can I do? Is this allowed, guys? No, this is identical or similar. Also, it should not be like, let's say, Sun Pictures. Sun Pictures Limited. I can't start. What is it, guys? Ada Hindi la translate panni. Surya Chitra Limited. You can't start. Similar. Are you following, guys? It should not represent in any form existing company. Are you understanding, guys? Now, let's say you incorporated India down LLP. Now what happens? Same provisions what we have in Companies Act. Do you remember in Companies Act section 16 of Companies Act? Rectification of name, and we also have cancellation of name. Let me revise Companies Act once. If any name is identical, the RD, Regional Director, will order the company to change the name. Such company has to change within 3 months. Once they change, Companies Act section 16, rectification. Once you change within 3 months, you will intimate ROC within 15 days. Companies Act. Then, if this is with similar name, if your name is similar to a trademark, then if somebody else wants to raise a complaint that Kothas Coffee, CK, that some other company can raise a complaint within, very good, excellent, within 3 years of incorporation of this dummy company. For example, if you have two companies, Adidas and Abibas, Adidas can raise a complaint against Abibas with RD within 3 years of incorporation of Abibas. Abibas only 3 years marriage, so you can't file a complaint now. Then this company, after you file a complaint, RD will again order back to here. Change name, 3 months, rectify within 15 days. Remember this rectification of name in Companies Act, copy, paste, LLP, same. Section number only changed, 17. Anga 16, inga 17. Are you following, guys? Same provision. Do you remember that in Companies Act, guys? Same. Are you following? Clear? Okay. If you don't change the name, in the order of the Pergu, if you don't change the name, then RD by itself will suo motu cancel the name of the company from the registrar of companies, or cancel the name of LLP from registrar of LLP. With this we will also cancel LLP in marathon. Done, guys. Following. Perfect. Okay. That's it. Clear? These are the core top 80-90% of LLP provisions that we have in syllabus. I think approximately 1 hour we are done. Now we will go to everyone's favorite, FEMA. I will give you the break after FEMA gets over. Let's take FEMA. Yes. புரியல. LLP. Yeah. Material for LLP. What you wrote now is the material. Running notes. See, this is enough, guys. More than enough what we wrote. Okay. Soft copy I don't have. This is the soft copy. What we wrote. You didn't write running notes now. That's it. That is enough for LLP. See, I can give it then. It's not done, guys, for LLP. That's why I gave you class notes. In class also I dictated. Even for us, we dictated. We spent 5 hours in dictating, writing notes. That's it. Those are the notes for LLP. Okay. I will maybe try next 2-3 days if I can do it. I'll make soft copy and share with everybody. If possible, I'll try my best. Maybe by April 10th, I will try to share it. Okay. Today is 5th. Today is over, guys. I'll try to give it. But do you all have, see, the same notes we dictated in class? Okay. Let's do 1 or 2 questions from LLP for you to get confidence. Before I go to FEMA. They're able to hear us. Google is hearing our examples. MTP, RTP both you have to download, or it's available there. You have to download. Login download pannuma. Okay, then after breaks we'll just get it ready here. Just remind me. Okay. After break we'll download and keep. Let's keep the latest MTP, MTP1 and RTP. Let's do FEMA LLP questions from there also to the extent possible. Okay. Fine. Guys, all of you with me. First to kurta notes la parstingla. LLP kurta notes la fulla parstingla, guys. Parstingla fulla notes. Getting late. Okay. Follow, guys. Before I go to FEMA, okay, let's proceed, guys. Hello, can we start? In latest mock test paper, they asked one question. We have to discuss one small. In section 92, what is 92 of Companies Act? Annual return. Over there, signing of annual return, we classified in case of 1-person company or small company, it was sufficient if one director or CS signed. This annual return for a small company or a 1-person company is a much smaller annual return, that is called abridged annual return. That's it. So what is abridged annual return? It's a shorter annual return for a 1-person company or a small company. That's it. Are you guys following? Clear. That's it. One small thing, it came in MTP, so we are discussing that. Let's go back to FEMA. In FEMA, if you see, I'm going to focus again on what kind of questions can come in exam. We did enough number of questions in class, guys. Yes, I'm going to focus on questions. What is the residential status in FEMA and what is current and capital account transactions? These are the main things that we're going to discuss. Okay. Guys, can we go? Can you want to do FEMA or something else? FEMA. Follow. Okay. Now let's understand residential status. The only 2 possible questions you can get in MCQ or thing is, at least from what I've seen, MTP and RTP, initial attempts, they're either asking, is the transaction allowed or not allowed in current and capital account? Is the person resident or not a resident? Are you following? The first thing you have to check is, in the previous year, has the person stayed for more than 182 days? Meaning, I will check residential, I'll teach this once. It's fairly easy. Exam oriented, I'll keep it, forget the logic. Now, for checking residential status in current year, I will check in the previous year if he stayed for more than 182 days. It is more than, intentionally I didn't change it here. It is for more than, not, it is just more than, guys. It's not equal to or more than. It's straight away more than 182 days in the previous year. Are you following, guys? You will ask this question. If the answer is yes, previous year he stayed for more than 182 days. Previous year, not previous financial year. Then in the current year, he is a resident. I will tell you what is resident or non-resident. For our ease of discussion, let's keep it as resident and non-resident. The correct term is something else. I will add that in the last. He is a resident. Current year is a resident. Now, in the current year, I am a resident. But in the current year, if you leave India for 3 particular reasons alone, then from the date of leaving, you will not be a resident. Let's say, if you leave for the purpose of business or vocation is projects over there, or employment, or you are leaving India where the period of your stay is uncertain is the words used. Correct? No? Uncertain. Period of stay is uncertain. You don't know when you are planning to come back. Unakke answer therilla. That's it. That's a simple. Okay. So, in previous year, if you stay for more than 182 days, in current year, I am a resident. However, in current year, if you leave India for these 3 purposes, then you are not a resident. Leaving India for this, then you become a non-resident. You are leaving India for other reasons, then you still continue to be a resident because previous year you stayed for more than 182 days. Are you guys following? Previous year I stayed less than or equal to 182 days. Then current year you are non-resident. I will replace this term later. Current year you are a non-resident. We will understand till here with 2-3 examples and then we will proceed. Okay, let's understand till here, guys. Let's say year 23-24, 24-25 is my current year. In previous year, let's say we'll take whom? Preeti. Okay. Preeti in the previous year stayed in India for 195 days. In current year, on 7th May 2024, she left to China. She left to China, guys. Now, this period, what is she? Resident. From the time she left, is she a resident? I will check the purpose of leaving. In simple, India whenever you come to India, check the purpose. She left to China for vacation. She wanted to go around, lot of food to eat. So she left to China for vacation. Example, guys. She wanted to go for vacation. Now, purpose is not in those 3 points. In the previous year, she stayed for more than. So she is a resident. Are you following, guys? Study math, there's a small mistake actually. I'm a vacation, vocation badla in one place. Don't message me asking, sir, why is it vacation? Other place it's vocation. Okay, study math, there's a mistake. Okay, small mistake, leave it. No, she didn't leave for vacation, sir. She left for, let's say, business or employment. She got a job in China, so she left to China for employment. Now, she becomes a non-resident from 7th May only. Residential status in FEMA is not for a year. It is for a particular period. Are you following, guys? Understood till here? Easier? Okay. Now, come back. This is for previous year and current year. Let's say, same example. Last year in India, she stayed only for, let's say, 175 days. Now, current year, this period she is a non-resident. Now she is leaving India. Let her leave for anything. Even if she leaves for vacation, previous year was less than 1 less than or equal to 182. No, it was less. Yeah, so she will be a non-resident. Even if she leaves for purpose of business employment, still she will be a non-resident. Are you following, guys? Understanding? Clear? So this entire period she will be a non-resident. This is leaving India. So when you are leaving India, just check the previous year. Let's say she did not leave India itself. Whole year she was in India. Previous year she stayed for 175 days. Current year she is a non-resident. Because last year is less than or equal to 182. It has to be more than 182 for her to be a resident. Are you following this, guys? So previous year less than or equal to 182, she becomes a non-resident. Next, let's say in the current year you are coming into India. Current year you are coming into India. Follow. Coming into India. Let's say any day you are coming into India current year. Okay. I will check the purpose why you are coming. If you are coming for the 3 purposes which is mentioned over here, if you are coming into India for other reasons, if you are coming into India for other reasons, then you will check other reasons. If you are coming into India for other reasons, what do? I will check the previous year if it's more than 182 days. Are you guys following? Coming into India for other reasons. Then I will check the previous year. If you are coming into India for these 3 purposes, then I don't check days or previous year anything. You are straight away. Are you following, guys? Sir, are you understanding? Let's say this year, financial year 23-24, financial year 24-25. Let's say on 3rd April 24, Ricky Pointing comes to India for purpose of business. Even if he stayed here for 182 days plus, even if the previous year he stayed for more than 300 days, if you are coming into India for the purpose of these 3 purposes, you are a resident. If you come into India for these 3 purposes, do not check for days. Are you following? Only if you are coming for other reasons, then I will check previous year if it's more than 182 days or more.
You told other than the 3 reasons, we have not to check the previous year. In the rectification video.
Yeah, rectification. That's what I'm asking. So this is what we learned. In rectification, if it's for other reasons, what we should do?
We should not check that previous year. He's a person resident outside India.
No.
So it's already a person residing outside India.
Which one?
So we should
He's a non-resident in the current year.
1 second. Okay. In current year coming into India, what did we discuss in rectification video?
without checking the previous year. Straight away you have to treat them as person resident outside India.
In this. Yeah, correct. Got it. Yeah. So other reasons we will check straight away if he is coming for other reasons. Correct. Yeah. This is what we learned, guys. Follow. No, rectification. Got it. Okay. This is what we learned. Correct in class. Hello. I'll just repeat so far what I have told. Follow, guys. In previous year, if you stay for more than 182 days, then current year you are a resident. Then current year, if you are leaving India for any other 3 reasons, I will check my previous year condition. I will take it resident or non-resident. But if you are leaving India for these 3 purpose, then you are a non-resident. That's what we learned now. current year, if you are coming into India, if it is for 3 purposes, you are a resident. Are you following? You are a resident if you come into India for 3 purposes. Now, this is the part where there was a rectification. This is what you all learnt. You guys, we got rectification, but not everybody saw that rectification. This is what you all learnt, guys. So here there is a small rectification, a small 10-minute video which I shared. I don't know how many of you got that video itself. So I wanted to again rectify. This is what we all studied. Leave you guys we rectified already. So if you are coming into India for other reasons, if you are coming into India for other reasons, this part alone there is a small change. What is that? If I am coming into India for other reasons, don't check days, you are straight away non-resident. This is the small change. Is that clear now, guys? Correct, Hari? This is the one. Yes, this is it. Are you following? I will again repeat. We will take some examples also, and then before we proceed. So are you following? Is everybody, Padma, getting it?
We don't have to check.
Yeah, that this is other rectification is no. Rectification what we saw previous year la, even if it's more than 182, current year if you are coming for other reasons, you are a non-resident. Idan rectification, correct? That is how the law says. Even if you are coming into India for other than these 3 purposes, even if you stay for more than 182 days, you are a non-resident. This is the change. This is what is there in the study mat also. This is the exception for that limb. The logic is you are coming into India for other reasons. I can't take you a resident. You are resident only if you come into India for these purposes. Following.
Vacation came back to India.
Okay.
Last year, I wanted to in the financial year, like say first April.
We will have examples. I will take example. Are you clear with this, Hari? This is what we discussed. Rectification you guys saw. That's it. Rectification is correct. This is the one final thing. Let me revise once, then we will take 3-4 examples to get clarity, guys. Follow. In previous year, if you stay for more than 182 days, in current year you are a resident. That's it. Previous year you stay for less than or equal to 182 days, current year you are a non-resident. Now, whenever you are leaving India, I will check the previous year. When I am leaving India, previous year if it's more than, current year I am a resident. If you are leaving India for other than these 3 reasons, if you leave India for these 3 reasons, then you are a non-resident. Are you following? Now coming into India is where the confusion came. We should clear it. Coming into India, if you are coming into India for 3 purposes of business, vocation, employment or period is uncertain, then you are a resident. I am coming to India. If you are coming into India for these 3 purposes, don't check time period, you are a resident. Here only the slight change where if you are coming into India for other purposes other than these 3 also, no need to check 182 days condition. If for that year you become a non-resident, next year you check the previous year days.
This one is who's a non-resident already.
Correct. This one who's coming into India who's already a, very important, who's coming into India who's already a non-resident. Resident coming into India is anyway resident. So non-resident is coming into India. First time Ricky Ponting is coming to India for tourism. He is not a resident. Are you getting it, guys? So this part is the change we have to do from what we learnt in class. Marathon, this is the final one. Are you understanding?
Yes.
Everybody is clear? Let me give 2-3 examples to understand. Following, guys. Hari, clear? Rather, I'm clear. Example I will give you. Pavitra, clear? This side everybody clear, guys? Padma, clear? No? So you guys from our offline class make the change only here, guys. I will anyway send this separate video snip to you, but make the change over here. Okay. Those who are watching in 3rd floor, just wake up now and make note of this. Just wake your neighbors, guys. If somebody is sleeping 3rd floor and others, this is the change you have to do, guys. Okay. Can we proceed now? Hello? Madhav, ready?
சார் நீங்க சொல்றது எப்படின்னா லாஸ்ட் இயர் ஆல்ரெடி நான் ரெசிடென்ட் ஆயிட்டாங்க இந்த வருஷம் ரிட்டர்ன் ஆகும்போது நீங்க பர்பஸா பண்ணணும்
Correct. India வரீங்கன்னா if you are a non-resident, see the purpose. That's it. Okay. Already non-resident coming into India, see purpose. Purpose for three things. Resident coming into India for other than this. Non-resident for that year. For the year you come in. Sorry? No, doesn't matter first time or already has come. What was his status when he is coming or not going? Are you following, guys? I'll give examples. Follow, guys. We still have half an hour for this FEMA. Follow, guys. Now everywhere where I used resident in our above example, you should not use the word resident. FEMA uses a term called PRII, person resident in India. Wherever I use the word non-resident, person resident outside India. Are you guys following? So PROI or PRII. In the entire FEMA restriction is only for a PRII and not much for a PROI. Are you guys following? I'll tell you why we have these restrictions once I finish this residential part before current and capital account. Follow, guys. All of you understanding till here? Okay. Now let's take a simple one or two examples. We will develop the example from whatever you guys give me. Financial year 23-24, financial year 24-25, financial year 25-26. Okay. Let's say before this you are always in India. Okay. Let's take Satya for example. Satya for the first time on 16th October 24, he is leaving to Thailand. Okay. He left to Thailand, guys. Okay. Now, tell me for this period, until he left, what is he? PRII. Now he left and never came back till the year ending. He left for the purpose of vacation. Now, what is he, guys? PROI. He's a PROI. Now let's make a small change. Instead of 16th October, let's say he left on 10th April 23 itself, beginning of the year, in the first 10 days of the year. And for whole year, he was in Thailand. He came back only on, let's say, 25th March 24. Year ending la vanta India. Okay. Now, he left for vacation. So this period is PRII. He left for vacation. This period also he is PRII, because we are leaving for vacation. I will check previous year. Previous year so far is always in India. So it's a PR. He came back on 25th March. He stayed in India till 31st March. Now when he is coming back to India, he is already a PRII. He is already a resident. He is coming to India for what purpose? Other than three reasons. Now what is he? He is already a resident. So he will still be a resident. Are you following, guys? Are you getting it? Okay. Now come to next year. Now for next year, what I will check? I will check his residential status in previous year. Correct? Number of days in previous year. In previous year, majority of the year he was outside India. He was in Thailand. Correct? So previous year he was in India for less than 182 days. So therefore current year, this year he will become a PROI. Are you getting it, guys? He becomes a PROI. But however, we have to ask the question, he is coming back to India for what purpose? Now, he is not coming for business. He is not coming for profession. But when he comes back to India after vacation, his stay in India is uncertain. Even though his resident is coming for India, but stay is uncertain. He has no other plans of leaving India again. That means, can I assume or can I say he is come for that three purpose? Then I will make him PRII. I can't say PROI. Are you getting it, guys? So when you go to vacation and come back to India, automatically you fall in the third category of stays uncertain. So you become a PRII. Are you following, guys? Clear? Next, let's again Satya, let's say next year, let's say on 16th September 24, This time he left to Bali. Indonesia, Bali. This time he left Bangkok, Thailand. இல்லையா அது கூட தெரியல. Okay. Same only no guys, different Same only no. Okay. So this time we went to Bali guys, but this time he went on a business trip. He went on a business trip this time. So until 16th September is a PRII. Now after he left for this period he is a because he left India for business trip. He came back because of business trip. He was there for a long period. He came back only on, let's say, 10th October 25. Till this entire period he is a PR. Now when he comes back to India, ask the purpose. Now he is already a PROI. So PROI coming to India, ask the purpose. Is he coming for 3 purpose? Business, profession. If he is coming for 3 purpose, then he is a PR. Illa sir, he is coming for other. He is coming to India for vacation now. And is again going back. Then he becomes a PR. Are you following? But he is coming to India where PR is uncertain. Then PRI. Clear? Is this fine? So I want you guys to try. If you really understood this concept or not, today itself, take the latest May 24 RTP. We will see if we have time today in marathon. Marathon is concepts. Take the May 24 RTP and mock test papers. Mock test paper and RTP is extremely important for LLP and FEMA because those are the only officially released questions by ICAI apart from your ICAI study material questions. In our class we have done more questions. We have done guys MTP, RTP. These questions ICAI study math, MTP, 2 MTPs and RTP for FEMA and LLP, be very clear guys because from ICAI study math, MTP, RTP, all template questions are there. 25 marks you will get FEMA and LLP. At least the first 2 attempts, all the exams in 2024, ICAI will ask from these template questions only, make some small changes. Idha thandi they will not ask. Are you following guys? That new chapters means they will generally ask easier questions now. Basic straightforward questions. Here I can tell expected questions. May 24 RTP, MTP and ICAI study math, which we have anyway done in all the classes where I have taken for you guys. Are you following? All the questions I have done. MTP, RTP, ICAI study math. Clear? This alone be clear. Yes, Mohit. Correct. His doubt is, sir, certain or uncertain எப்படி கொண்டு போறீங்க? நீ தான் சொல்லணும். நீ எதுக்கு வரணும் நான் தான் கேட்பேன். So you have to make a declaration when you come for immigration process. Is your stay uncertain or certain? Correct. It's a declaration you give. Yes. Which? Thailand. No. Thailand is first case, no. Bali. Not, he's going for vacation. It's not for other. See, he's leaving India for those 3. See, that here we are assuming he will come back. He's going for vacation. We are planning his trip. So other than 3 reasons. If he is leaving to Thailand for uncertain period, then he will become PR. Over. It depends on. That's why even the study math says the third limb, uncertain certain, is a very complex limb where it's very subjective to what the person declares. Got it? Yes. Here I have not assumed. I have told he's gone for vacation. But institute will clearly give certain or uncertain. So it's a problem in practical life, not for exam. Exam will definitely drop that hint somewhere. Clear? Yes, Riya, Satya. Proper. Visa கொடுக்க மாட்டாங்களா? marathon பண்ணி டைம் கம்மியா இருக்கு, சீக்கிரமா சொல்லு. Okay, nothing. Yes, Danish, no doubt.
Yes, sir. Sir, during the vacation he says that he will be returning only for next year, sir.
Okay, so during, good question, we have in study mat also. I went with a mindset of staying for a certain period in Thailand. But after going there, I decided, now my birth period from certain became uncertain, then the residential status will change. But like Satya says, that visa will have a validity. Tourist visa 6 months. That means you have to come back again, renew only and go. So the purpose of visa will be taken as the period. Tourist visa, that means what is it? certain period, maximum 6 months. Are you getting it? That's your doubt, Satya? Yes. No, if he's non-resident coming into India, check the purpose. Last case when he's coming back to India. Last case when he's coming back to India on 10th October, he's already PROI. So I will check the purpose. If purpose is for 3 reasons, he's a PR. Others, PROI. Even if he stayed in this year for more than 182 days or previous year more than 182. Following, clear Vasundhara? Anybody else, any other doubt? Yes.
Sir, in the same vacation example, he said he will be returning he will return next year June, sir.
Okay.
Then during this financial year 23-24, will he be?
He is saying he'll return next year, June. Thailand or Bali? Thailand. He will return next year, June. Purpose of leaving another business or profession or vacation. Leaving vacation, that means PR, II. For the same previous year. That's it. Can we proceed, guys? Anybody has any other doubt? Clear, guys? Just to summarize one more time. Guys, we can keep debating on this, but question, let's check for this. Previous year I stayed for more than 182. Current year I am a resident. Previous year I stayed for less than or equal to 182. Current year I am not a resident. This is the standard rule. Now exceptions. Current year, even though I am a resident, if I am leaving India for 3 purposes, then you are a PROI. If you leave India for these 3 purposes, you are a PROI. If you come to India for these 3 purposes, you become a PRII with irrespective of days. Only when you come back to India for other reasons, still I will be considered as non-resident irrespective of days if you are a PROI coming into India. Are you following, guys? Clear? Understanding? Now let's proceed. Now why we have FEMA? Now FEMA is going to get over in next 20 minutes. After this, concepts are lesser. We just have provisions that you have to remember. I'll tell you what they are. First of all, why we have FEMA? If you see, logic punjada, the next schedules you will understand. Let's say quickly, Dhanush from Chennai, he imported and he purchased, let's say, a t-shirt. Okay. For t-shirt, he purchased for $100. Okay. Some branded t-shirt. Now he has to pay in dollars, but he has only rupees. So he will go to money exchanger, banks for asking dollars. They will get from whom, guys? RBI. RBI get a pay. RBI, I need $100. $1 is 80 rupees. Take 8,000 rupees. 80 into 100, 8,000. RBI is saying, Nanga for $92. Wait, Dhanush. RBI went to World Bank and took a loan. $dollars. How much? $100. Gave Dhanush. Dhanush purchased that t-shirt. In the example, the person who's selling the t-shirt, let's say Tommy, okay. Tommy from US is selling that t-shirt. Tommy is happy, Dhanush is happy, RBI is not happy because they borrowed from World Bank $100. Are you guys following? Same way, later Dhanush, he started his own textile company in India. Now he is exporting shirts. Let's say Gopi from US. Gopi be US lerpa. But Sami, okay. Sami, okay, in US. He purchased this t-shirt, okay. So let's say Dhanush sold it for $200 now. 80 rupees assuming per dollar. One shirt is 16,000 rupees made in India. 16,000 rupees he sold one shirt, okay. Fine. Now this Sami is paying $200 to Dhanush. Dhanush is saying, I don't need not dollars, I need rupees. So now Sami will go to RBI and tell RBI, take this $200 and give me 16,000 rupees. RBI will tell, I am searching for you only, give me that $200 and they will give 16,000 rupees. RBI will give that money to Sami, Sami will give it to Dhanush. Now Dhanush also is happy. Tommy and Sami both are happy and even RBI is happy because RBI got $200. Now they can repay the loan of $100 with interest, whatever they have left $100. First, when Dhanush purchased the shirt from Tommy, he didn't import. Later, when Dhanush sold it to Sami, he didn't Export. In India, which is more? Export is more or import is more? Import is more. That means whenever an import happens, we need dollars. We beg RBI, RBI goes and begs for dollars. Yes.
So இப்போ இந்தியால இருக்கவங்க இப்போ தனுஷ் வந்து இம்போர்ட் பண்றப்போ அவன் டாலர்ஸ் வேணும்னு சொல்லிட்டு ஆர்பிஐல வாங்குறான். ஆனா சப்போஸ் இப்போ ஃபாரின்ல இருந்து ஒருத்தர் வந்தறப்போ அவன் ஏன் ஆர்பிஐ நிக்கணும்? அவன் கண்ட்ரியோட பேங்க்ல தான சொல்லிடுவான்.
He will ask his bank. That bank will ask RBI. He will ask World Bank. World Bank will ask RBI. Okay. Clear? Now next, coming to tourism. Indians go abroad for, sorry, let's say foreign nationals come to India, tourism is more. Indians going abroad for tourism is more, or foreign nationals coming to India for tourism is more? Indians going abroad. Honeymoon, you are only planning abroad. Okay, so again, Indians going abroad is more. If you are going abroad, you need dollars. Same way last, Indians studying abroad is more, or abroad students studying in India is more? Indians studying abroad. That means always you need dollars, and RBI is always begging for dollars. So RBI is always on a dollar deficit. That's why they keep saying, come on, you do export in India, make in India, promote tourism in India, let other people come and study here, you study here and so on. So there is some dollar deficit. So remember, FEMA does not keep any restriction when dollars are coming into India. Export, export promoting, export, tax is exempt, all of that. Only when dollars is leaving India, we are going on deficit. That's why we have FEMA to manage this, which says if dollars is leaving India, we classify those transactions into two types: current account transactions and capital account transactions. Current and capital account. What they are saying in current and capital account transactions? In current and capital account are basically transactions which affects my trading and P&L. Capital are generally which affects my balance sheet. If you want to do these transactions, there are some restrictions over there. Basically, these restrictions are covered in approximately 6 schedules, 3 for current and 3 in capital, where they tell what is allowed, what is not allowed. Another 20-30 minutes we will finish all of this. Let's understand what is capital account transaction. For a person resident in India, if his assets or liabilities outside India is altered, or for a person resident outside India, if his assets and liabilities in India is altered, this is called a capital account transaction. Are you following? In one of these two only contingent liability will come. Where? First case we have also contingent liability. Let me give example. Let's say Ria purchased the car in Chennai. Is this a capital account transaction? No. Ria is a PRII. She is buying an asset. Asset is altered in India. It's not a capital account transaction, even though it's affecting her balance sheet in India. Ria purchased a house in New Zealand. Is this a capital account transaction? Yes. Alters assets or liabilities outside India. Adhe madri PROI, Ricky Ponting is buying a house in Australia. Is it covered in our standard? Covered in our law act? No. Ricky Ponting is buying a house in India, asset or liability in India, then it becomes a capital account transaction. Are you following? Why contingent liability is only here? For example, let's say in US, Elon Musk took a loan. For that, Ria from India has given guarantee to the US bank that if Elon Musk doesn't repay, I will pay. Now, Ria paying this liability is doubtful. It depends on Elon Musk not paying the loan. So for Ria, it's a contingent liability. If it becomes certain, then she has to pay. Dollars going out of India, so it becomes a capital account transaction. Sir, apona PROI India la asset vaangana. Yes sir, why not allowing? They are allowing. It's allowed in. It's a capital asset made in India. Money is coming in India. They allow it. That we will see in schedule. So follow very carefully. They are saying capital account transactions are not allowed unless schedules allow for it. It's the negative definition. You should not do capital account transactions. Anyway not allowed unless schedules allow it. Same way in current account transactions, the schedules tells yes what you can do, no what you should not do. Are you following? So exam questions will be like this. Idu pannalama, we should not do it or not. So let me quickly go there. So dealing in foreign exchange, one more thing. Dealing in foreign exchange between anybody in India is not allowed. No person shall deal in foreign exchange in India unless they do it through an authorized person, who's authorized to deal with foreign exchange. Meaning Elon Musk comes to India, goes to Sangeeta Hotel and he pays money. He pays in dollars. He can't pay. No person in India should accept dollars. Let's say, sir, I want Netflix account, not Indian Netflix. I want US Netflix account. So I asked my friend in US. He gave me his credentials. I am making the payment because I want to use the account. You are paying dollars outside India directly without a authorized person, not allowed. Are you following? For example, sending dollars in India to a friend for consideration. Sir, in Vietnam, my brother has some dollars. I am selling it to my friend. No, not allowed. Paying Netflix membership in US for your friend there or paying for your own account over there. From here, not allowed. Elon Musk eating in Sangeeta restaurant and paying in dollars, not allowed. Shivaji movie, that Hawala transaction, not allowed. Entering into a financial transaction in India to acquire any asset outside India, not able to understand, sir. Ria has a house in New Zealand. So I'm giving her, here take Ria 10 lakhs. She took 10 lakh rupees here or she took some dollars here. I'm buying the asset over there. Any of the forex transactions should happen through an authorized representative. Are you guys following? Now coming to schedules, guys. Schedule, simple. Current account there are 3 schedules. Capital account there are 3 schedules. You have to memorize these points in schedules wherever limits come, which is allowed and which is not allowed. First, schedule 1 of, I will finish current account, guys. Straightforward exam questions. If you see, look at the RTP, they will tell, when there was one RTP or MTP question, somebody in India is doing a remittance out of lottery winnings. Can they do it? No. Like that they will ask, Panlama Ilya, yes or no. That's how your questions will be. Are you following, guys? So in schedule 1 they say, for these transactions, foreign exchange is prohibited, not allowed. You can't take foreign exchange out of India for this. Remittance out of lottery winnings. Sir, I won lottery in Kerala. Can I take the money out of India? No. Already won lottery. Don't take it outside India. Next. Remittance of income from racing, riding or any other hobby. I participated in horse race in Chennai, Madras Race Club. I won it. Can I take the money outside? No. Remittance for purchase of lottery tickets, banned or prescribed magazines, football pools or sweepstakes. Kamesh, are you following? Okay. Remittance for purchase of lottery tickets. You want to buy a lottery ticket in US? Not allowed. If you see this French show, there will be this lottery happening in US that you can't buy. Any banned or prescribed magazine, you can't, already banned. For that you can't put forex in, buy. Football pools, no football betting, like Dream 11 in India, other countries have their apps. You can't play that over here, from here. Like this, these are not allowed, means not allowed. Sir, now Panta sir, I didn't tell you, I have this sir. Now, helmet, if you don't wear helmet, 1000 rupees penalty. But without helmet you are driving. Nobody caught me. What is it? You didn't get caught. You are in non-compliance of law, but you are not penalized yet. Sir, I purchased, sir. Lottery ticket, sir, US lottery. I purchased magazines and kept, sir. It's there in my house, sir. Nobody knows about it. Now, that means you are in non-compliance of law by using FEMA, but you are not caught. Are you following, guys? Clear? Let's proceed. Okay. Fine, come back to topic, guys. After exams, we discuss all of that. Next. Now, we are going to explain some terms. Considering marathon, I can't explain logic of these terms. Anyway, in our regular class for everybody, we have spent at least 4 to 5 hours on FEMA. Each of these points, what is callback service, what is non-resident special scheme, what is dividend balancing, I explain. You don't have to know the logic for exam. What is dividend balancing? No need logic. For those watching marathon, Just understand, if you pay for commission on exports towards equity investment in joint venture, or if you pay for dividend balancing, or if you pay for callback service, or if money is interest through non-resident special rupee scheme, all these are not allowed. So in the question, if you find dividend balancing, not allowed. Are you following? Considering marathon, I am not teaching you what is dividend balancing. We have regular videos for that, online students recording, you can take that and watch it. Okay, fine. Following, if you have the time to spend 5-6 hours, but I am sure everybody knows this. Clear? I will only focus on the key points where limits are there. Payment of commission on export under rupee state credit route, except commission up to 10% of invoice value of export of TN. If you export goods in India, let's say I want to sell water bottle. Okay, now water bottle I sold outside India. How I sold? I had an agent there. Rajaram is my agent in UK. He helped me do the sale. I can't pay him commission. Not allowed. Commission is allowed up to 10% of invoice value if I am exporting tea and tobacco, because that time India was one of the largest exporters of tea and tobacco, so they are allowing commission up to 10%. Are you following, guys? These are all completely prohibited. Coming to the most exam like top schedule is schedule 3. It's a scheme called LRS scheme, liberalized remittance scheme. What is he saying in this scheme? Up to $250,000 you can freely use per individual. Sir, in my family we have 4 people. Then you can use 250,000 into 4. You can do clubbing also. One person can use 4 lakh, other person can use 2 lakh. I can mix and match, but maximum 4 for the most common purposes. Why you go abroad? Adana cover pannidom. Sir, I can't go abroad, sir. I have medical treatment. I need $5 lakh. You can do it. Get permission of RBI. What are these things? Private visit to any country. Satya wants to go to Thailand. Private visit. He can take up to $250,000. Other Malu he needs money. Get permission of RBI. Gift or donation. Going abroad for employment. Straightforward points. Maintenance of close relative abroad. Then after going to Thailand, he made a relative over there. For maintenance of the relative, he can withdraw up to $250,000. Travel for attending a conference or specialized training. Then studies abroad, medical treatment, or all of any other current account transaction up to $250,000. Exam, I'm focusing exam oriented. You can't withdraw this money if it's for Nepal and Bhutan. Are you following? Because you can pay in rupees. For limited career, okay, next. Whatever I have underlined here, immigration, studies abroad, and for medical treatment, whatever is underlined, for those things, you need to get proof, certificate if you are crossing the limit. Like studies abroad, college should give a certificate. Medical treatment, hospital should give certificate. Immigration, that particular country visa department should give it. So for these purposes, if you are crossing the limit, for all of this, you need to provide the, evidence has to be given. Are you following, guys? Whatever is there, even if it's within the limit, they will ask for evidence. Okay. Next. This is schedule 1 and 3. Next we have schedule 2. Here also it's all little dry points, guys. Whether I teach in marathon or regular, these are points which you need to be aware of, where these are allowed only with permission of Government of India, and there are some departments. Straightforward understanding points. I'll just give you randomly few points for you to see. Cultural tours, they ask in RTP and MTP, allowed only if Ministry of HRD allows. Then this is the latest question which came in mock test paper. Remittance of prize money, sponsorship of sports activity abroad by a person other than international, national or state level sports body, the amount involved exceeds $1 lakh. For example, BCCI is conducting IPL in Dubai. For that they want to withdraw $10 lakh to give for man of the match or of the finals or something. Is there any limit? No. If a sports body of international, national or state level is making a contribution, there is no limit. There is no limit up to 1 lakh. No limit. Only if private bodies, let's say TCS is conducting international football tournament, in that TCS wants to withdraw money. Apart from this, then you have to get up to 1 lakh, more than 1 lakh get permission of Ministry of Human Resource Development. Are you following, guys? Like this we have some, this is one limit, this is another limit. Advertisement in foreign print media for the purpose other than promotion of tourism, foreign investment and international bidding, if the amount exceeds $10,000. How do you understand this point? Now who is doing the advertisement? Public sector undertaking is doing advertisement for what purpose? If they are doing for purpose other than tourism, foreign investment, international bidding. So tourism, foreign investment, international bidding. What is the limit? No limit. If you are doing for other than these three cases, limit of 10,000. If the advertisement is done by public sector undertaking, sir, purila sir. Let's say public sector undertaking, BSNL is doing a Facebook advertisement in other countries saying we are launching BSNL 3G now. Okay. Now, it is for purpose other than tourism. What is it? Foreign investment or international bidding. It's for other than these three. Then limit is 10,000. If BSNL is saying they are doing for tourism, come on, come visit India, you will get signal everywhere. Then if it's for tourism purpose, there is no limit. Are you guys following? Understanding of? Like this you have to break down all these points. How do you remember this for exam? Just be aware of the points. Multimodal transport. Keywords da use pannuvom. Multimodal doing multiple transports, or remittance of hiring charges by transponders for TV channels or internet service providers, Hathway, all of that. Remittance of freight for vessel chartered by PSU, or remittance for container retention charges. All these are allowed only with permission of Government of India. Here there are two limits in this schedule. 10,000 for PSU, 1 lakh for sports. This 1 lakh sports they asked in mock test paper. Are you following, guys? Clear? This, beyond this there is not. I can explain what is transponders. It transfers signal here and there, but they will not ask you all of that. We are in a marathon, just be aware. In the schedule allowed only with Government of India's approval. Are you following? Like this we have one more schedule for other than individuals in current account. Again these are 4 points. I am not going to brief much. Here there are limits, guys. Quickly. Point 3 talks about consultancy service. Consultancy is of 2 points. If consultancy is for investment, consultancy is for others. So I didn't know what to do. I am calling some foreign expert to give me consultancy how to do VFX in movie. It's for consultancy other than infrastructure. Other than infrastructure. I am calling some foreign construction company to help me build a flyover. So if it's for other than these purposes, then the limit is 1 million. Other than it is $1 million in dollars. If it is for infrastructure, it is 10 million in dollars. Are you following? If you are importing service, importing consultancy service for infrastructure, $10 million. Other than infrastructure, $1 million. Are you guys following? Perfect. Like this there are 4 points. Commission per transaction to agents abroad. This no broker app is there. Agents help us buy or sell houses. For sale of residential flat or commercial plots in India exceeding 25,000 or 5% of the inward remittance, whichever is more. What is this? Sir, my house in India, somebody abroad is buying. I have a house in Chennai. I sold it to Ricky Ponting. I was able to sell to Ricky Ponting because I found a broker there. For that broker, the commission should not exceed $25,000 or 5% of the inward remittance, whichever is more. Are you following? 25,000 or 5%. You have to make notes for this case. Our Gen Z notes will be very helpful. Just make crisp notes. Donations exceeding 1% of the foreign exchange earnings during the 3 previous years or 5 million, whichever is less. Donation for all these purposes. Donation for some technical institution, some research, or some buying some chairs in reputed institutes. Not these chairs. Buying chairs means buying some seats, designation, all of that. Donation for seats. Are you following, guys? Clear? Understanding? And last point here, remittance exceeding 5% of investment brought into India or US dollars 1 lakh, whichever is higher, by an entity in India by way of disbursement of pre-incorporation after investment comes into India. If you are doing reimbursement of pre-incorporation expense, reimbursement of pre-incorporation expense should not exceed 5% of investment brought into India or 1 lakh, whichever is higher. Are you following? Are you getting it, guys? I am not teaching the concept, I am telling you. Remember these limits, guys. These, if up to this limit we can do it. Beyond this, we can't do it. Next, what is this dabba? If anybody from other than India, foreign nationals come to India and work in India, salary earned here can be taken back. You can't tell you can't take salary back because they're coming here for working. But if that person is from Pakistan, then he can't take the money back to Pakistan. Are you following? That is one. And the duration of such job shall not exceed 3 years. Are you following? Clear? No other option than remembering these points. Clear? Then there are some exemptions. This is not that important. If it comes from RFC account, EEFC account, then there is no approval needed. In simple, if money comes from RFC, resident foreign currency, or exchange earners foreign currency, no approval. Logic. These accounts will be in dollars. Are you following? Okay. Next. Similarly, capital account transactions, there is one schedule which says schedule 1 is what PRII can do. Schedule 2 is what PROI can do. And schedule 3 is important. Prohibited capital account transaction. Let me finish off this part quickly because this they are asking in MTP, RTP. Now, just like how current account has a limit of 2 lakh 50, capital account also has a limit of 2 lakh 50. But this transaction you cannot do with some countries which is not allowed by Financial Action Task Force. FATF is a department of government, very strong and powerful, where they don't allow you to do transactions with some countries. Like some non-cooperative countries and terrorist countries, this FATF does not allow if you give funds for them. And also they don't allow you to do transactions with people in North Korea. You can't buy or sell any assets. தெரியாம நீ வாங்கிட்டேனா you have to sell within 180 days. Are you following, guys? Okay. Why North Korea? If you visit North Korea for tourism, you will not have freedom. There will be always a guide with you. You can't take video in North Korea. They will confiscate your phone. You have to go around. அவன் எங்க சொன்னாங்க நீ photo எடுக்கணும். You can't record videos. It's a very highly dictatorship country. You will not have basic freedom rights also, but recording is there. I should be safe. Next. Okay. The person resident outside India is prohibited from making investment in India. Like let's say Ricky Pointing outside India cannot make investment in India in the following businesses. Again you should remember, in the business of chit fund Ricky Pointing can't invest. In business of Nidhi company, agriculture or plantation activities you can't invest. Real estate business or construction of farmhouse not allowed. But what is allowed is the term real estate does not include development of township. That means township development they can invest. Construction of residential or commercial premises. Let's say ICA nearby, they're constructing an apartment called One Crest. It's construction of residential house, they can invest from outside India. Let's say next to ICA, have you seen this big One Crest building, guys? One house is 15 crores there. Let's say Ricky Pointing wants to buy a house there, he can buy. Construction of residential or he's constructing, or construction of roads and bridges, real estate infrastructure trust, they can invest. What he can't invest, real estate business apart from this two, or construction of farmhouse, not allowed. Are you following, guys? Clear? They don't talk about acquisition here, it's subject to interpretation. Construction, acquisition of farmhouse, not allowed. Okay, next. Trading in TDRs, transferable development rights. What is TDR? Let's say, for example, Satya's house is here or Satya's office is here. Okay. Metro construction is coming here. So Satya's office is going to become new metro station. So government has taken away his property, but government won't give him money. They will give him TDRs. This has ownership in this land. After 10 years, when metro comes here, after 15 years, when metro comes here, now Satya can sell these TDRs. He can sell the ownership in land without selling the land. Are you following? This TDRs will take the value from the land. It's like owning real estate but in paper. Are you following, guys? Transferable development rights you can't buy. TDRs are given by government when they give consideration for surrender of land from owner for confiscation for whatever purpose. Are you understanding? These are not allowed. These two schedules are opposite. PRII allowed. Let me read some examples just for you to be familiarized. Only 5 more minutes. I am not reading the points. The point is if investment by a person resident in India in foreign securities. I will read the example. Let's assume Shah Rukh Khan from India. Shah Rukh is buying Tesla shares. Indian resident buying shares outside India. Shah Rukh is taking loan from World Bank. Foreign currency loan raised in India and abroad by a person resident in India. Are you following up? Transfer of immovable property outside India by a person resident in India. Shah Rukh is selling his house in Dubai. Are you getting it? Are you understanding? Okay. Next, you read this point. Guarantee issued by a person resident in India in favor of person resident outside India. Shah Rukh was giving guarantee for Musk for taking loan taken by Musk. Our example, Ria is giving guarantee for Musk taken by loan. Allowed. Shah Rukh is holding forex notes. He can have up to the limit of 2,50,000. Next, Shah Rukh is borrowing from Warren Buffett. Allowed. Look at the wording, sir. Loans and overdraft borrowing by a person resident in India. Shah Rukh from a person resident outside India. Shah Rukh borrowing from Warren Buffett. Are you getting it, guys? Example per se will be very easy. That's why I gave example in the book itself. Next. Next. Having balance in Swiss bank. Maintenance of foreign currency account. Allowed. Next. Taking an insurance policy by person resident in India from an insurance company outside India. Biggest insurance company in the world. Allianz German. You are taking insurance from Allianz German. Are you following? Like this, these points, loans and overdraft. Shah Rukh giving loan to Elon Musk. Taking loan or giving loan. Remittance outside India of capital assets of a person resident in India. What is this? Now, person resident in India. Shah Rukh already sold his house. He sold this house. Shah Rukh selling his house in Dubai. Now, this money, if it comes into India, again is remitting outside India of capital of a person resident in India. Shah Rukh, let's say, is selling his house in Chennai and this money is taking it outside India. There will be some restrictions up to 2,50,000. This is 2,50,000 is for common everything, guys. Wherever I am telling you all these are allowed. Correct? All these allowed should not cross 2,50,000. That only I gave it here. See. No person can undertake to enter into any transaction in Schedule 1 if it's crossing 2,50,000 per financial year. That means whatever I am saying allowed here in the Shah Rukh example, everything, it's allowed up to 2,50,000. And last one, undertakes derivative contracts. Shah Rukh trading in derivatives in US stock exchange. He's buying and selling in US stock exchange, Nasdaq. Are you following? Exactly opposite points is for a person resident outside India. For example, Elon Musk is buying ICA building in Chennai. Are you from there? Or next, say acquisition. Next, Elon Musk is selling the ICA building in Chennai and takes the money back to US. These are allowed. Are you following, guys? The difference between this schedule and previous is, if you look at the previous schedule, here you have only transfer of immovable property outside India. Shah Rukh is selling his house in Dubai. But here they also added acquisition and transfer of immovable property. That means Elon Musk can buy building in Chennai and he can also later transfer it, and after transfer it, read point G. It's related. He can buy in India, sell in India and remit the money back outside India. So Elon Musk can come to India, buy Chennai ICA building, sell that building, take the money and go back. Are you following, guys? Clear? Then other points are same. Elon Musk giving guarantee for Vijay Mallya loans to India. Elon Musk and Shah Rukh giving deposits to each other. Your friend bringing currency notes into India. These are all similar opposite points. Are you following, guys? Have a quick read in the note. Just be aware. For this they have not given limit of 2,50,000. Only for schedule 1. The limit of 2,50,000 is given only for schedule 1, guys. They have not given it for schedule 2. Following. This is FEMA. Are you all getting it till here, guys? Are you able to follow what you should read for exam? The last 10 minutes I didn't teach you anything much. I just read what is there in the book. I genuinely don't like doing that, but at least I wanted to tell for those who are reading first time what is allowed, what is not allowed. If I just summarize, current account has schedule 1, schedule 2, schedule 2, schedule 3, and they have a schedule for non-individuals. Capital account also has 3 schedules, schedule 1, schedule 2 and schedule 3, correct? Now capital account, the last schedule what we saw is prohibited. That investment in Nidhi, chit fund, South Korea, North Korea, all these are prohibited. Capital account schedule 1, what is allowed for PR, II up to 2,50,000. Schedule 2 is what is allowed for a PROI for assets and liabilities in India, capital account, correct? Current account schedule 1, prohibited allowed. Dividend callback service, dividend balancing, lottery ticket, schedule 1. Schedule 3 is allowed in a scheme called LRS scheme up to 2,50,000. Schedule 2 is Government of India approval. You need Government of India, central government approval for things like cultural tours. Generally these are done by organizations, non-individuals, not organizations like government is doing, PSUs and the non-individual. We have 4 points. It's allowed up to a particular. Here there are 4 limits. That buying chairs, then residential plot commission, all of that. This is for those 4 specific transactions. You need to get permission of RBI for this. So you should know which falls over there. Wherever there is a limit, if you are aware, you can get your full 10 marks in FEMA wherever it comes. Material, everybody has soft copy or hard copy. That's about it. Are you following, guys? To end, one last point in FEMA. If I would have given a note towards the ending. If a person resident in India, a person resident outside India acquired some assets and liabilities in India when he was a PR, II, he can continue to have it, correct? This is one general exception. When a PR, II purchase some assets and liabilities outside India, when he is a PR, OI, he can continue to have it. Example, let's say Ricky Pointing coming to India, when he became a PRIA, when he bought some asset in Chennai, he can continue to have it even after becoming PR. No restriction in that. He can do anything with that house, no limit. PRIA, Sundar Pichai went to Google US. He outside India in US, he bought a house in US when he is a PROI. So if you are a PRIA today, but you got an asset or liability outside India, when you are a PROI, such asset liability can be done. You can do anything with that without any limit. These are one general exemptions that we have without any limit. Are you following this, guys? First one, this one is basically PROI purchased asset liability in India when he was a PRIA. He purchased or also inherited. They also use the word inherited in both. Purchased or inherited in India when he was a PRIA. Same way PRIA purchased asset liability. You purchased asset liability outside India when you were there and when you were a PROI. This is allowed. General exemptions. Are you following, guys? Ensure for these 2 chapters, FEMA and LLP, you guys go through the RTP, MTP and past exam questions once. Now it will be easy. With this we conclude FEMA and LLP. Any doubts, anybody? Perfect. Okay. Okay, let's proceed our marathon. So coming back to Companies Act, from section 77 to 148 we already finished in the morning session. What we have left in Companies Act is basically section 1 to 76, and we also have foreign company section 379 to section 394, correct? Foreign company. Now the remaining time, the last 2 hours 15 minutes, whatever we have left, I'll be focusing purely on this part, section 1 to 76. We will complete maximum that is possible over here. For those who are watching recording and even for you guys here, what we are not covering in this discussion, but you will have the marathon video for offline. Those who are watching recording, check the description. Like I said, interpretation of statutes, General Clause Act, and even foreign companies, the regular itself is just 1.5 to 2 hours. We have good quality recording over there. So these 3 links I will anyway be uploading in this video. Check the description. You guys also will be getting it if you just find it once the video comes. Now we will spend maximum possible time in 1 to 76. We will go in the same order of reverse and try to go till 1. Okay. Now let's quickly go to deposits chapter. Another chapter where we can score marks. Deposits is only 3 sections, 73 to 76. We will spend half an hour in deposits. If you look at these sections in deposits, 76A is penalty for not following the provisions of this chapter. You will have a look at the penalty section once. 75 is not there in syllabus, which is damages for fraud. 74 is a very small section which says repayment of deposits that you accepted in the previous Companies Act 1956. This you have to repay within 3 years or 3 months. Within 3 years from the time of when this act came in 2014. So old act deposit should be repaid within 3 years from the time this act came in. Are you following, guys? This is a transitional provision. It is dead for now, which is of no use at this point. But even if they ask, old deposits of old act should be repaid within 3 years. If you want a longer period, you can extend, you can check with ROC. Are you following, guys? So the 2 core provisions we have here is 73 and 76. Only 2 types of questions have been tested in this chapter so far. 73 and 76 is about procedure for deposits. 73 is deposits from, for any company, public, private, if you want to raise deposits from members. 76 is deposits from public. So if you want to raise deposits, what's the procedure? And again, this chapter tells what is not a deposit as well. What is not a deposit? For this we have one list. So we are also going to discuss only these 2 parts over here. What is not a deposit and what is the procedure for deposits? Most questions come over here. Let's quickly go there. Deposits page number. Okay, 82. So this is what we understood now. How they have defined deposits, if you see, they have defined in 2 subsection 31, which says deposit includes any receipts of money by a company by way of deposit, loan or any other form. Again, what are they saying? Deposit includes any receipt of money by a company by way of deposit, loan or any other form. For example, let's say we'll take ITC sold some chips, bingo chips, on which they received 20 rupees from the customer. Now, is this deposit for ITC? As per definition, literal interpretation, rerun, is it deposit, guys? Yes. Deposit includes any receipt of money by a company. ITC received money by way of deposit, loan or any other form. ITC went to ICICI Bank and took a loan of 100 crores. Is this deposit? Yes. Deposit includes receipt of money by a company by way of deposit, loan or any other form. Now let's say you paid money for Netflix subscription. Is it deposit for Netflix? As per definition, yes. Deposit includes any receipt of money by way of deposit, loan or any other form. That means if company is receiving money in any manner, it becomes a deposit. Are you guys following? So this is like defining food includes everything. Then I will tell food does not include rubber, ink, plastic, lead, all of that. Are you following, guys? So it's like a reverse definition which says food includes everything other than what you can't eat. That means what is food is not defined. Are you following, guys? So deposit definition also is like that. This definition includes basically everything. Now you have to learn, or we have to see what is not included in the definition of, what is it? Deposit. So here they are giving you a list of some 14 items which says what is not a deposit. This we have to be aware about it. They will ask sometimes 6-mark question, 3 examples. Deposit or not a deposit. So now I will just give you some examples. Apply common sense and tell me is it deposit or not. We will quickly go and see if it's there in this list. 10-15 minutes, 10-15 minutes procedure, and that's it. Let's say our same example. ITC took loan from ICICI Bank. Deposit or no? ITC took loan from, let's say, central government. Is it deposit? No. ITC took loan from, let's say, foreign bank. Is it deposit? No. They took deposit from US government. Is it deposit, guys? No. They took loan from Airtel. Is it deposit? No. So first few points, if you see, any amount received from central or state government, any other source where repayment is guaranteed by central or state government, money received from local authority, not a deposit. Any money received from foreign bank, international bank, subject to FEMA regulations, is not a deposit because it's a loan. Are you following? Understanding context of definition of amount received from banks as a loan facility or from other company, intercorporate deposit is not a deposit because it's a loan. Are you getting it, guys? Okay. Next, if you remember prospectus chapter in private placement, when we go there or when you already learned, in prospectus chapter, application money received should be allotted within 30 days. Otherwise refund within 15 days. In private placement, application money should be allotted within 60 days of receipt and again refund within next 15 days. Until this period, so here it is 30 plus 15, 60 plus 15. This is section 39, this is section 42. Until this period, this is not a deposit. But if you have not repaid from the 46th day and from the 76th day, then it becomes a deposit. That's what they're saying in this point 4. Are you following, guys? Debenture holders gave money to me. Is it deposit? It's what? Debentures. Money from debenture holders or bond, whether secured, unsecured, is not a deposit. Like this we have to learn in negative way. Then listed convertible debentures without a charge on the asset is not a deposit. Listed non-convertible deposits. Next, what are the key points here, sir? This is a KPA example. Money from directors or relative of directors of private company is not a deposit. Why they are saying this? Let's say you have a private company, you started a business. Let's say you started, let's say Good Health Private Limited. Now, the 2 directors are just you and your friend. You are not involving with the public itself. So you want to invest money in your own company. You don't want to put shares. So you want to put your own company. You want to give loan. You want to give deposit. Or your relative, your uncle is saying, take 10 lakhs investment. It is my deposit for your company. Now, if I have to follow procedures of this chapter, there are so many procedures. So they are saying, if directors or relative of directors of private company give money to the private company, it's not a deposit. Are you following? Sometimes when employee joins a company, he has to pay security deposit. Because if I give employee bike, car, laptop, if he takes everything and runs away, I will collect some security deposit from him. So security deposit received from employee without interest, not exceeding his annual salary. Let's say Dhaneshwar's annual salary is 18 lakhs. Now he is giving deposit to his company of 12 lakhs. Is it deposit? No. Correct. Not more than 18 lakhs annual salary. He is giving 22 lakhs as deposit. Is it deposit, guys? Yes. So he is giving only 6 lakhs deposit. No. 6 lakhs is giving a 2% interest. Is it deposit? Yes. The minute interest comes, it becomes a deposit. This point they can test. Are you following? Next, amount held in trust. What do you mean by amount held in trust? I gave Janeshwar 1 lakh and told, keep it, I'll come and take it from you next week. He's holding, I am giving the money to him, amount held in trust. Like if somebody gives money to a company for safekeeping for trust, it's not a deposit. Next, we'll come from reverse. Let's say, if you pay for AC, AMC, is it deposit for AC company? No. And advance towards consideration of future service in form of warranty or maintenance contract, annual maintenance, as per the agreement, but the provision of service does not exceed 5 years or service as per general trade practice, whichever is lower. Generally, AMC is paid for 1 or 2 years, but this company is saying our terms AC, AMC is for 3 years, it's allowed. Up to 5 years you can pay if the company allows. Now company is saying AC maintenance, 7 years you pay together. No, we'll allow only up to 5 years. So annual maintenance or warranty charges maximum is 5 years. But if company is doing such lower period. Are you following? Now sometimes you might pay for Netflix subscription. Let's say print media, Mint app or InShot sometimes has premium subscription. You pay for that news. So advance for subscription towards publication to print. Hindu you pay 1 year advance for getting newspaper. For prints or electronic media to be adjusted against receipt of such publication. Are you following? Print or electronic media means classic example is OTT. You pay 1 year in advance. For them it is not a deposit. Are you following, guys? Clear? Next, security deposit. Okay, advance received by sectoral regulator in the directions of central or state government. What is this? For example, very good, advance tax. Income tax department is collecting advance tax because of income tax act. It's not an deposit. Sometimes they collect money from Airtel for some deposit. It's not a deposit because government is asking to collect all of this. Are you following, guys? Clear? Next, security deposit receipt for performance of contract of supply of goods or service. Sometimes I will place order with Srimittai. I want 100 kgs of sweets. They will tell give one deposit. That is not a deposit as per this unit. Are you following, guys? Definitions like this, we eliminate a lot of these points. Now what are the next key points here? Let's say you go to Srimittai and you purchase 100 kg of sweets you want for this year Diwali. Now itself you are buying 6 months in advance. What entry will Srimittai pass when they get money from you for 100 kg sweets? Let's say you paid 50,000. What is the entry they will pass? Bank account debit to advance on sale, which is happening today. Let's say in April 24. Later, what is happening? In Diwali time, let's say November 24, they gave you sweets, so you don't have to pay. You paid advance now. So now they will give you the sweets. Entry will be to sale and I will debit what? Advance on sale. Is this deposit, guys? No. Are you following? This is not a deposit because this is nothing but advance for purchase of good. This entry and this entry should be set off within 365 days. Are you following? Illa sir, this entry is passed in April 24. Set off entry is happening after 365. Let's say it's happening in 2026. Then it becomes a deposit. Why will you pay advance such early? If you want to buy something, maximum 1 year time back, bro. Are you following, guys? Clear? Same way, instead of sales for Srimittai, let's say advance is given to buy a house. So you purchase the house with Casa Grant. Entry, Casa Grant got advance now. 2 lakhs you paid. They are going to construct. It's going to take them 3 years, 4 years for construction. So that time they will pass entry, bank to house advance. Correct? Later after 3-4 years, when they sell the house to you, entry will be house advance to sale. They will pass it. Now these two entries are more than 365 days. The provision doesn't allow. So the time limit is not applicable if it's for purchase of what, guys? Any supply of capital goods. So look at point 9. Trade advance received and appropriated against goods and service within 365. But advance receipt for sale of immovable property for capital goods, no time limit. Time limit is as per the contract. Casa Grant says house will be ready in 5 years. After 5 years only I will do set off entry. Then it's not a deposit. but contract says 5 years, actually it took 7 years, then after 5 years it becomes a deposit because you crossed the contract period. Are you following, guys? Clear? Now, let's say in October let's say April you ordered sweets. In August, the restaurant or whatever sweet shop closed down. So they can't provide you sweets in November or December, correct? Now they will provide refund. That means the contract is cancelled now. They are not unable to perform. Now this money should be refunded. Will it become deposit? Yes. In these cases where a contract for which you give advance and contract is cancelled for whatever reason, money has to be refunded to you within up to 15 days. It's not a deposit, same 15 days period. Once it crosses 15 days, it becomes a deposit. That is what is given here. In point 9 and 10 above, which one? This trade 365 days point in capital goods, where the amount becomes repayable for such reason as the company is not licensed to provide such service or for any other reason, then such amount becomes a deposit after expiry of 15 days when the amount is due. Let's say government told Casa Grande, don't build house anymore. It's not good. So they lost license, CMD approval. Now they have to return all the advances. Up to 15 days, not deposit. Then it becomes deposit. Are you guys following? Perfect. Next, the amount accepted by. These are some basic cases. If you pay money to mutual fund, not deposit for them. Collective investment scheme, alternate investment fund, it's not a deposit. Let me give an example. Tell me if it's a deposit. We'll take Bajaj Finance. Let's say we'll take Hari is going to Bajaj Finance and giving 10 lakhs of his money for saving over there, and he's getting a certificate that he made 10 lakhs investment. Is this deposit? Is this deposit, guys? Hello? It is a deposit. Other than a deposit, my person giving it, everything is not deposit just because I'm talking about what is not a deposit. What's a deposit? You go to a company, give money and get deposit receipt. What is actually deposit? Going to a bank and putting a FD and getting FD certificate, that's a deposit. But instead of going to a bank, you're getting FD certificate from a company. Learn what is deposit. Don't say everything is not deposit. Clear, guys? Okay. Next. Amount received from chit fund or nidhi company in accordance with provisions applicable to them. So investment in chit fund, nidhi company is not a deposit. Are you following, guys? What is nidhi company? A group of community of people. Among themselves, they raise deposits and give money to each other. So it's not a deposit as per this provision. Chit fund also similar. I collect money from all of you, give it to somebody, get the money returned to you along with interest. Are you following? The next important point. Startup company receiving more than 25 lakhs from a single person in a single tranche received as convertible into equity shares or repayable within 10 years from date of. So either you received a debt which is repayable within 10 years, or you received investment into equity shares. It becomes a deposit if the money received is startup company more than 25, startup company more than this is not a deposit. So if you receive more than 25 lakhs from one person in a single tranche, it's not a deposit. So example, let's take a startup. Let's say, for example, okay, Miko, MICO is a startup. Let's say for the startup, one venture capital fund is giving 2 crores as a startup funding. Is this deposit, guys? No. It's more than 25 lakhs. It's not a deposit. Sir, they gave me 2 crores, but every day they gave 10 lakhs. It becomes a deposit. Sir, I got only one-time payment. 20 lakhs, one-time payment. Is it deposit? Yes. Yes, it becomes a deposit. So, if you receive only more than 25 lakhs in a single tranche, in a single payment, then it becomes a not a deposit. Sir, I got 30 lakhs, 20 lakhs once, after 1 week 10 lakhs, then, but it should come from the same person. Let's say Ria gave 20 lakhs, 10 lakhs Padma gave, again 10 lakhs let's say Dinakaran gave, then it's not a deposit. Are you following, guys? Clear? I will again repeat. If you receive more than 25 lakhs from a single person in a single tranche, now one transaction, If it's issued as debt or convertible into equity share, it's not a deposit. Because if more than 25 lakhs means it's startup funding. Only less than 25 lakhs it becomes a deposit. Following is Mohit.
Then in that
Example? 20 lakhs? 10 lakhs? 10 lakhs. No, I told this is given from different person. No. Ria gave 20 lakhs. So with Ria it's not a deposit. Sorry, yeah, correct. Ria gave 20 lakhs, Padma gave 10 lakhs and Dinakaran gave 10 lakhs. 3 different people on 3 different days gave less than 25 lakhs. It's not a deposit. It's a deposit, sorry. It's a deposit. Now let's say, I'll just change it. Ria gives 30 lakhs, Padma gives 40 lakhs, Dinakaran gives 60 lakhs. Now it's not a deposit. Now these 3 amounts, all are given by Ria itself on 3 different days. Then it becomes a, let's say, Ria gives 20 lakhs today, 10 lakhs tomorrow, again 10 lakhs day after. Is it deposit? Yes. Because it's given in different tranches, even though it's more than 20. So she gave full 40 lakhs on the same day, but morning 10 a.m., 4 p.m., 8 p.m. Then deposit. Are you following? Sir, in simple, if I get more than 25 lakhs from a single person in a single tranche, then it's not a deposit. Less than 25 lakhs is deposit. Or if you get more than 25 lakhs in multiple tranches on different days or same day, then it is a deposit. Clear? Confusion over, guys. Following? That's it. Okay. Important, it has to be a startup, guys. Here our startup is. So how do I know? Here, okay, Mind and Company is a startup. It's my startup, I know. But you guys know it. But how do you know it's startup in exam? It's a startup. Generally, startup is a company in the first 10 years of their incorporation. Are you following, guys? Okay. Understanding this? Yes.
What is not a deposit?
Yes.
More than 25 lakhs, not a deposit.
More than 25 lakhs? Yeah, not a deposit. Correct. Kamya on a deposit. Correct now? So if, let's say Hari is giving, I'm having a startup, Hari is giving me 50 lakhs. Not a deposit. Hari is giving me 20 lakhs. It becomes deposit. General startup funding you get more amount, 25 lakhs that is not deposit because it's funding. Startup funding 20 lakhs so they're saying it's a deposit. Got it clarified, Hari? Yes. Amount limit. If it's any amount more than 25 lakhs repayable within 10 years. Why they are saying generally debentures are payable within 10 years. Then they are saying it's debentures, so it's a debtor. It's not a deposit. Repayable after 40 years. Then it becomes a deposit. Hari has given me 50 crores for investment in equity. Is it deposit? No. Hari gave me 50 crores in one transfer for investing in shares. Is it deposit? No. Hari gave me 50 crores for buying debentures in my company. Repayable in 7 years. Is it deposit? No. Hari gave me 50 crores. I will repay to him after 30 years. Is it deposit? Yes. Repayable in 30 years. Then it's deposit. Now don't see amount. Repayable within 10 years. I am making it 30 years. Are you following? Are you following? This again is important. Clear, guys? Okay. Clear, guys? Following? Next, the last point, guys. Promoters loan by way of unsecured loan due to a stipulation imposed by the lending institution and loan by promoter and their relatives. This is not a deposit until the loan is. I'll give example. Let's say Adani went to HDFC Bank to take a loan. Okay. He wanted 100 crores loan. Assuming Adani is a private company. Now HDFC told, I will give you a loan if you give Adani itself should give to Adani Private Limited 5 crores loan 100. So Adani gave 5 crores to Adani Private Limited as a condition of the financial institution. This 5 crores is not a deposit. Later if Adani repays this 100 to HDFC, then this becomes a deposit if it's not repaid. Are you following, guys? Now read the point. Promoters loan by way of unsecured loan due to stipulation imposed by lending institution HDFC and loan by promoter Adani and their relatives. This is not a loan until the loan is repaid. Main loan is repaid. Are you following, guys? These are the points. What are the key points here? If you see that 45 days, 75 days point from directors and relatives of directors, not a deposit. Security deposit up to 12 months of non-interest bearing security. Then this startup company, mutual fund, nidhi, all of that. 365 days and supply of capital goods. That point. Are you following?
That promoter loan you said last one.
Yeah, promoter loan.
That is only for private limited or also public?
No. Here it's for any company. Promoters loan by, it's for any company. Private or promoters loan by unsecured loan, lending institution, loan by promoters, not a deposit, loan is repaid. They have not mentioned private or public. This could be private or public. It could be any company. Now if this is private company, anyway director's loan is not a deposit. So only if it's a public company, this is not a deposit if you give the money because of a lending institution's condition. Are you following? Clear up? So this is one type of question, guys. If deposit comes in exam 10 times, 6 or 7 times, he will ask like this. He will give 3 things. Deposita illaya kepa. Are you following, guys? Easy or difficult? Second is the procedures. I am only going to focus on the key procedures over here. What are my key procedures? 1. Who can issue deposits? Follow, guys. Deposits from members, deposits from public. Can private company issue deposits from members? Yes, they can issue 100% of deposits from members. Can private company issue deposits from public? No. Go to a public company. Public company is classified into 2 types here. Non-eligible and eligible. Non-eligible company, non-eligible public, can they raise from members? Yes. Members, can they raise? Yes. How much? 35% of what? Something I will tell you. 35%. Can non-eligible public company raise from public? No. Eligible public company, can they raise from public? Yes. Can they raise from members? Yes. The percentage is 10 and maximum 25%. I'll explain this. What he's saying here, a eligible public company can raise overall 35%, but from public maximum 25. So here if it's 20%, here it can be 15. Here if it's 10%, here it can be 25. Here can I have 30%? No. Here maximum is, that's why you have here 10. Are you following? Can I raise from members 35? Yes. Then from public it will become 0. This is for eligible public company. Only an eligible public company can raise from public. What if it's an eligible government company? For eligible government company, they are saying you can raise how much, guys? You can raise 35% in any ratio between public. That means here also I can have 35. Here I can have 0. With public I can have 35. With members I will have 0. Which is not possible for an eligible public company. Are you following? Whenever you can raise from public, which is an eligible public or eligible government company, that is my section 76. Whenever you can raise from members, private company or public company which is non-eligible, or public eligible from members, or public eligible government from members, then it becomes. So 73, 76 is not classified based on type of company. It's from whom you are raising money. Members na 73, public na 76. There are multiple procedures to follow. I will only focus on key. This is one. Sir, what is this percentage, sir? Percentage is what? All the above percentage is a percentage of paid up share capital plus free reserves plus securities premium. That means if my paid up share capital is 100, free reserves 100, SP 50, total is, then private company can raise in balance sheet another 250 only from members. Are you following, guys? Clear? Public company from members, they can raise only 35% of 250, which is whatever 76.25 something is coming. Clear, guys? Are you guys following this? Understanding? Next. What is the time limit of deposit in all the above case? This is the full chart. In all the above case, time limit is minimum. I can't issue deposits for more than less than 6 months. 6 months to 36 months is the period of deposit in all the above deposits. Can I go for a shorter period? Yes. I can do it for 3 months to 6 months. Minimum 3, maximum 6. But the above percentage, whatever, 100, 35, 25, whatever, is restricted to 10% of paid up share capital plus free reserves plus securities premium. Are you following, guys? This is next key point. Next, after this is done. Next one. What is an eligible company? Eligible company, another, guys. Only they can raise from public. There's a limit which is net worth is more than or equal to 100 crores or turnover more than or equal to 500 crores. Are you guys following? So they are saying eligible company, net worth is more than or equal to 100 crores, turnover more than or equal to 500 crores. Any one, if you cross, you become an eligible company. Eligible company should also be only a public company, and they should have passed the necessary resolution, OR or SR as the case may be, from its members. Are you following, guys? This is eligible company. Next, now a private company is saying, a private company, let's say mind and company start now, me and my brother are 2 directors or 2 members. Why are you giving me limit? Now publicly affect panliye. Why can't I invest more than my paid up share capital is just 1 lakh? Because when I started the company, they said paid up share capital should be minimum 1 lakh. So you are saying I should only raise only 100% of this, whatever reserves is there. Why can't I put 10 lakhs? My savings I want to put into the company as deposit. Why can't I do that? So the law says, okay, fine. Private company, I should not keep restriction. So if you want to go for more than 100%, in certain cases, they allow that. You can go for more than 100% when they are saying, okay, you are a startup company, you need money, okay, startup private company for more than 10 years from the date of commencement can have it for more than 100%, no limit, without any limit. Or, sir, I am not a startup company, then you are some other private company, then you have to follow these 4 conditions, then you can raise from more than 100%. 1. Such a company is not an associate subsidiary of any other. I am a standalone company. I don't have a holding, I don't have a subsidiary, I don't have an associate. That means the tani company, small company, just small group of people. Next, company has not defaulted in filing annual return or and financial statements. Annual return section 92, FS section 137, and has to file details of money collected to the registrar. So you have not defaulted in filing this. Are you following? Next, this how many years? Okay, not default in filing these 2, and you should file this to money to registrar. Let's say how much your money you collected. Next, borrowings of such company. Before that, company has not defaulted in repaying any other borrowings. I might have some other borrowings I should have not repaid, and the other borrowings I have should have a limit. What is that limit? Borrowings of such company from banks or any other body corporate is less than twice of its paid up share capital or 50 crores, whichever is less. Sir, let me understand this. What is this point saying? Let's say my borrowings is in balance sheet. I have a share capital of 20 crores and my borrowings is 30 crores. What is this saying? The borrowings of such company which is 30 crores from banks or financial institution or any other body corporate is less than twice its paid up share capital. What is twice the paid up share capital? Or 50 crores, whichever is, which is less here. My 30 is less than 40, so I can proceed. 30 is my borrowings. My existing borrowings is less than twice of my paid up share capital of 50 crores, whichever is less. Are you following? What is he trying to communicate here? Debt equity ratio. He is trying to say your capital debt equity should not be more than twice of the paid up share capital equity. Your existing borrowing 30 should not be more than twice of equity in solran. Debt equity podalame. Your debt equity should not cross 2:1. But they have written it like this. Are you following, guys? Let's take another scenario. Let's say my share capital is 120. Share capital is 120. Now 2 times share capital is how much? 240 or 50, whichever is less. It's less than 50. Yes. So now why they have not told straight away debt equity? Let's say borrowings is 100. Borrowings is 100. Now 2 times my paid up share capital is 240. Borrowings anyway 100 up. Isn't it less than 240? That means my debt equity is 100, so debt by equity. So 100 by 240. It's less than 2. But I am not allowing because you already have 100 crores of borrowing. I will not allow more deposits. The maximum borrowing you can have is only 50. That's why he's saying 240, 2 times paid up share capital or 50 crores, whichever is less. That means the minute my share capital crosses 25 crores, I don't have to apply equation. Because if my share capital becomes 26 times 2, 52, I will do 52 or 50, whichever is less. Then I will compare with my existing borrowings. Are you following, guys? Understanding? If you want to apply one last time, let's say share capital is 30 crores, borrowings is 45 crores. Allowed or not allowed? For going for deposits more than 100%. Allowed. I will compare 45 crores versus 2 times 30, 60 or 50, whichever is less. So I will take 50, 45 is less than 50, I will proceed. Are you following, guys? So if these conditions are met, what are the conditions? My startup can either be my private limited can either be a startup, private can either be a startup, or company is not an associate subsidiary of any other company, or borrowing such company from any other body corporate is less than twice its paid up share capital or 50 crores, whichever is less. Not default in paying any other borrowing. Company has not default in filing 92 and 137 and gave details of deposits. Then you can go for any unlimited. That means in this case, I can even go for 10,000 crores of deposit. No problem. Are you following, guys? Clear? Understanding? Super. This same exception is also there in one more section. We have a section called 67, providing financial assistance, prohibition of providing financial assistance by a company directly or indirectly to any other person to buy back its own shares. But here the exception they are saying, this has 2 exceptions. 67 I am finishing. What is 67, guys? No company should give a financial assistance to any other person, individual company anyway, directly or indirectly to buy back my own shares. That means I can't give 10, I am the company, let's say I am Tata Capital or Tata Power. I can't give 10 lakhs to Hari, asking him to buy back shares of Tata Capital. Let's say Padma Limited, I am giving her 2 crores to buy shares of my company. No, I can't give it. You cannot give financial assistance. Why, sir, you should not give financial assistance? Let's say Tata Capital is giving a loan of 20 crores to Airtel. Airtel is using this money to buy shares of Tata, correct? So now Airtel has investment in shares of Tata, let's say 20, and they also took a loan of 20. Now Airtel should repay the money. They are not able to repay the money. So what is the entry for repaying this? Loan to cash. Avana solran loan badala I will give you investment. So I will set off both. So that means you will get back your shares instead of getting the loan. So instead of loan you will get investment in Tata Capital, investment in myself. So asset side my shares, liability side my shares, I will set off. It becomes an artificial buyback without following procedures of buyback. So 67 says you can't give financial assistance, but two exceptions. Then if I can't give financial assistance, the SBI is saying, now our bank loan now. What you do with the loan, how I will know? So they are saying a bank can give loan in the ordinary course of business. In ordinary course of business, I can give loan. And second, they are saying a company can give loan to its employees which should not exceed 6 months salary. And such employees can buy shares of the company, but those shares should be fully paid up, not partially paid up. That is another important point. So a company is allowed to give loan to employees because company and employee help on. So I can give loan to my employees up to, you can even give 1 year salary. But that employee, that 6 months salary can be used to buy back shares of the company only fully paid up. Again partly paid up, it will be set off. One set off comes. So if I am company, let's say I am Reliance, I can give loan to my employees to buy shares of my company, but that loan should not exceed 6 months salary if you want to buy shares of my company. Are you getting it? These two are allowed in section 67. Are you getting this, guys? 67, these two are allowed. This whole section of 67 is not applicable for a, if the same 4 conditions are satisfied. Are you following, guys? If 4, there is some deposit exemption where more than 100% allowed for a private company if you satisfy these 4 points. Same way in 67, the whole section of 67 is not applicable. If the private company satisfies these 4 limits, then private company can give loan to its employees to buy back its own shares up to any limit. Are you guys following? Clear? Understanding? Yes or no? Hello? Yes, this section 67, deviation from this chapter because it is related. Yes. Loan should be given only for, thanks for adding, only for employee. You can't give loan to director or KMP because salary. You can't give loan to them. This is only for genuine need purpose. Are you understanding? Clear? This is key provisions in deposits chapter. Are you following? Same thing we have here. Same chart is there in the book. Then I would have come down here. Time limit. All these points are there here. Now, I am not getting into the unique and common points. There are some other general points. You can go through these points. Just fairly procedures. I will discuss only few things. Deposit redemption reserve and few points over here. With respect to debentures and deposit, we will do a comparative study. Okay. Debentures, deposits, let's do a comparative study. In debentures, a company issues debentures to my debenture holders, deposits are given to my deposit holders. In both the cases, we have someone in middle called a debenture trustee, deposit trustee. In both the cases, we have someone, debenture trustee and deposit trustee. In both the cases, you have to create something called DRR. I'll come to DRR in the ending. What is DRR? I'll explain with percentages. But both cases, we have someone called deposit trustee and debenture trustee. What is the work of this debenture and deposit trustee? He will take care of debenture holders' interest with the company. If company wants to communicate something to debenture holders, they will do it through the debenture trustee. Same for deposit trustee. I will come to DRR in the ending. Now, what is the comparative study over here? Here, the debenture trustee has to be appointed when? After how many days of the issue? For debentures, it's before or after? After the issue. Debentures after, guys. 3 months. The debenture trust deed. Sorry, debenture trust deed. So here I have something called debenture trust deed. What is debenture trust deed? It's an agreement between debenture trustee, company and debenture holders, should be made within 3 months after issue is closed. Here deposit trustee is appointed when, guys? Here when is he appointed? Before the issue. How many days before issue? 7 days. Correct? I'll explain the logic how you will not forget. In debentures, the number of people are going to be fixed. Same set of people. Correct? Meaning, debentures can be purchased only for a particular period. Offer opening and offer closing. Then I will know exactly who are my debenture holders and I can go for an issue. Correct? I can go for a debenture trust deed. But in deposits, people don't have an open or closing of offer. You can keep making deposits on a daily basis. Today, tomorrow, next week, next month. How you go to a bank and make deposit? Every working day. For a company also I can make deposit on every working day. So here I can't close that even our debenture holders or even our deposit holders. Here deposit holders will keep coming. So here before issue 7 days. Are you following, guys? Clear? Next. Debenture trustee is not needed if the number of debenture holders are debenture trustee is mandatory in the following cases. So that means it's not needed if the offer is made for less than 500. So if the number of debenture holders is less than or equal to 500, up to 500 debenture holders, you don't need what, guys? Debenture trustee. Are you following up? Up to 500 debenture holders, no need to create a debenture trustee or a trust deed. Here we don't have such kind of a provision. That means you need to have deposit trustee. Are you following this, guys? Next. I am doing only comparative study, guys. Follow. Next over here. That means when it's mandatory, if company is making prospectus, public issue or any other offer inviting public, you need deposit trustee. Next. In both the cases, debenture trustee or deposit trustee, I am using DTDT but meaning is different. Debenture and deposit, they are liable when? If they have not done the work properly, if they were not diligent. So here we have some percentages for deposit trustee and some numbers to remember. 3/4 in value, 3/4 in value, then 1/10 in value, majority in number. For deposit also we have only one limit, 1/10. Correct? What is this percentage? 3/4 in value, 1/4 in value, majority in number. Simple. 1/10 in value of debenture holders can call for a meeting of debenture holders. Are you following, guys? How in shareholders EGM 1/10. Here also debenture holders 1/10. For deposit also 1/10 in value can call for a meeting of deposit holders, mainly with the deposit trustee. Are you guys following? Clear? We did this. I will revise. That's it. Deposit are limited career. Only one thing. 1/10 of deposit holders can call for a meeting with the deposit trustee or debenture trustee. This side. Here also 1/10. Debenture trustee or deposit trustee by their own suo motu also they can call. Are limited career. I can call whenever. How board can call for EGM whenever they want. Here we can call by them whenever they want. Are you following? Next, majority in number, what they will do? They will fill casual vacancy in the office of debenture trustee if caused by resignation only. Only if caused by resignation. If it is not resignation, then Board itself will fill by themselves. Are you got same like Companies Act auditors? You will have that here. Yeah, so caused by resignation. Otherwise, board itself may fill the casual vacancy. Casual vacancy, one majority in number, guys. This is simple majority in number. That's what is given. Yeah, majority of debenture holders, and this should be in writing. Are you following, guys? 3/4 we have two things. If you want to remove debenture trustee, remove him, then I will pass 3/4 in value. Are you following? Or if you want to exempt him from damages, 3/4 in value, again have to pass a resolution. Are you guys following? Clear? What do you mean by exempt him from damages? Let's say we'll take Maniraj is the debenture trustee. He had to go and be cautious, be diligent, but he was not diligent, because of which debenture holders lost money. Who is liable? Maniraj. But he is saying na vala panna. So if debenture holders to the extent of 3/4 in value pass a resolution, he is exempt from damages. Are you following, guys? They want to remove him. 3/4 should pass in value, should pass a resolution. Are you following the comparative study, guys? This side. Next, the comparative study. Who cannot be debenture trustee or deposit trustee? Who cannot be debenture or? Deposit. You think logically. Can a shareholder be a debenture or deposit trustee? No. Can employee be? No. Employee of company? No. Somebody, can existing bank who gave loan be debenture trustee? No. Can debenture holder itself be debenture trustee? No. Can deposit holder be debenture trustee? No. Not allowed, because all these people have some kind of relationship with the company. That means you are more bothered about the relationship you have with the company over the other relationship. Are you following, guys? So that's not allowed. So they are saying who cannot be a debenture trustee. Same points will apply for who cannot be a deposit trustee, except one change. So beneficiary holds shares na shareholders. Promoter, director, KMP or officer or employee of the company or subsidiary or associate. Any kind of relationship not allowed. Relative of promoter, director, KMP, straightforward points, guys. I am not reading through most of them. Indebted to the company, holding or associate. Not only the company, company's holding, subsidiary, associate. If you are indebted, or pecuniary relationship amounting to 2% or more of the gross turnover or total income of 50 lakhs during the immediately preceding 2 years, then this one point alone is not there for deposit, but we have it on the 2% career. They just use the word material pecuniary relationship. That means anything material. They are not defining what is material. So in deposits chapter they are defining material as 2%. There they are not defining. Are you guys following? Or you are given guarantee for any principal debts secured by the debentures. Meaning you have provided guarantee for this debenture issue. You have provided guarantee that company will repay. You can't be debenture trustee. Are you guys following? Clear, guys? So this is the only one point which is different between debentures and deposit. Last one, what is DRR? Debenture redemption reserve or deposit redemption. Sorry, correct. Debenture redemption reserve or deposit repayment reserve. Percentages. First flat standard. In deposit it is what percentage, guys? 20%. In debentures it is, remember, 15. But we have some changes based on case. Deposit, thankfully no change, 20%. Here it is 15%. How much, when should I make this payment? Before, assume this is financial year 22-23, financial year 23-24. Before 30th April 2022, that means before 30th April of the start of the financial year, let's say this year 80 crores of deposits are repayable. Next year 120 crores is repayable. before 30th April of this year, you should transfer to DRR. What is DRR? P&L account debit to debenture redemption reserve. At least our percentage was 15% of debentures maturing next year. What is debenture maturing next year? 120. 120 times 15% is how much, guys? How much, sir? 18 crores. So you will transfer to DRR before 30th April 18 crores, which is 15% of deposits, debentures maturing next year. At the same time, this balance should not fall below 15% of debentures maturing this year. It's already more than 15%, so I will maintain how much? 18. Let's go to next year, financial year 24-25. Let's see that next year what is repayable is 100 crores. So now this year again I will do a double check. DRR should be at least 15% of 100. I already have 80 now, but I might have used, let's say I have only 18. And it should be at least 15% of 120. I have 18, it's fine. I already have this 18. What is 15% of 100? 15. 15% of 120? 18. I need to have 18 then. I already have 18, nothing to do. What if this becomes 250? Then you already have 18. What is 15% of 250? 37.5. You have to add extra. Are you following, guys? Simple as solluna. This 120 you transfer in the current year for next year. Next year you will again check if that 120 is there. Are you following? So the provision is that 15% before 30th April should be debentures or both same, debentures or deposits maturing in next financial year. At the same time, it should also be debentures and deposits maturing in the current financial year. Both it should be there. Are you following, guys? Clear? Next then you transfer pantingna. This current year you would have transferred in previous year itself. Correct? It's just to check if it's already there. Are you understanding, guys? So what is the percentage you have to remember, guys? 15% for debentures, deposit 20%. Are you following? Now what if deposits are not repaid on time? That 6 months to 36 months. 6 months to 36 months we saw, guys. If they are not repaid on time, interest is 18%. However, there are some more points over there. Which are, this I am not taking much. In DRR rate, debentures alone there is one dabba which gives in different scenarios different percentages. Standard rate is 15, but in certain cases like banking company, All India Financial Institution, it is exempted. And in certain cases like unlisted companies, it is only 10%. Are you following? So you will just have a rough idea, guys. In other words, mostly it is 15%. You keep 15% in mind. Banking, All India Financial Institution now exempt. Unlisted company when it's now 10. NBFC not registered means again 15%. Create DRR means 15%. Are you following? They have given different rates. This used to be tested in accounts before. It was actually part of accounts, redemption of debentures. Now that is transferred to CA Foundation. Redemption of debentures. I am still ready to take class for them. I don't know how I will teach that over there. But accounts law it's not there for you guys, but law you have these provisions. With this we are done with section 71 or 2? 71 is what all we saw now post lunch. Follow. From 77 to 148 we already finished. Yes, sir. Now I finished few key sections in 70 series. 67 we finished. Yes, sir. Financial assistance. 71 is what? Debentures. 72 not. 72 not there. 73 deposits from members. 74 transitional provisions. 75 not there. 76 deposits from public. Are you following, guys? After this I will jump to a different chapter, but just one more thing over here in deposits. Few key procedures. I told interest is how much, guys, if you don't pay on time? Interest is 18%. Few key points over here. From the time the person makes deposit, three important timelines you have to remember here. From the time someone makes a deposit, in the register of deposits, you have to make an entry within 7 days and give him deposit receipt, and the certificate should be given within 21 days. Are you following? And every year you have to file return of deposits before 30th of June. So every year from end of financial year, start of financial year before 30th of June for the previous financial year, you have to file before 30th of June. This is called return of deposits in form DPT 3. You have to file with ROC. Three important timelines in deposit. One is return of deposit should be filed within 30th June of every financial year. Register update within 7 days when he gives money, and 21 days give him deposit receipt. Last two important points over here. If somebody is doing a pre-closure, he gave deposits for 3 years, he is closing in 2 years, then I will reduce penalty 1% interest. Very important. I will reduce 1% interest. Are you following, guys? Hari gave deposit for 3 years. Suddenly in 9 months he is closing it. Then I will pay him money, but not 10%. I will pay him 9%. But in two cases, this 1% is exempted. I will not reduce. In case of war risk, for war purpose I am pre-closing, or deposit is premature to comply with prescribed limits. This is a beautiful point. Let's say paid up share capital is 100, reserves is 100. For a eligible public company from public, how much they can raise? Eligible public company from public, 25%. What is 25% of 200? 50. So this company made deposits of 50. Now I got loss next year. So this 100 reserves became 50. Now my limit is 25% of 150. How much is that? 37.5. So this 50 should be reduced to 37.5. Therefore, that reduction is premature to comply with prescribed limits. Are you following, guys? Last point which comes in MCQ, with this I will close deposits. The maximum number of deposit holders can be 3 members, joint deposit holders. MCQ he will ask sometimes. What are the different terms they have? Let's say I have A, B and C, 3 deposit holders. If I use the word jointly paid, that means it's paid to all the 3 equally. If I use the word either party's name mentioned or survivor, that means I will pay to whom? Let's say I mentioned pay either to A or B. Then you can pay to A or B. Are you following, guys? That's it. Or survivor means if A dies means I will pay to B. First named or survivor, I am giving first to C, next to B, then A. Pay in that order. And last one, pay to anyone. Company's choice, they can pay to anyone. Are you following? With this we are closing deposits. We are also closing 70 series. Okay, perfect. If you see 70 series, all the sections are debt related. 71 is debenture, 73, 76 is deposits, 77 is charge. Debt na create a charge. 73 is full of debt. This is what mostly you don't study, so we are covering. Now what I will do, share capital chapter, I will give you a template as to how do you study. I will do that in the last. For everybody studying first time, how do you remember procedures? I will do it for a few procedures like ESOP and 43 rule 4. Big procedure, buyback also I will do it for you. We will shorten it easily so you get the confidence. That much big procedure, how do we remember in exam? We will all remember together now itself, but that will be the last thing we do, last 20 minutes. Because I already have those procedures ready, Gen Z notes ready. We spent lot of time in share capital chapter. I itself gave Gen Z notes for all topics in share capital. Now in the 1 hour we have left, I want to cover more provisions from the start of the act. So let me start off with section 1. What is section 1? Title of the act. Section 2, what you learned today. 2 subsection 40, financial statements. 2 subsection 85, small company. I'm going to go from 1 because 1 to 40, like this we can finish most of the provisions. Okay. Next, section 3, minimum number of members. In a private limited company, minimum is 2, public minimum is 7, maximum private is, public is, that is 3. Section 3A, unlimited liability, same provision we saw in LLP, where if the number of members fall below 2 or 7, as the case may be, you have to fix it within 6 months, or the liability becomes unlimited. Super. Next we saw section 4 and 5. What is 4? What is 5? This you would have studied many times, foundation, school maybe, inter MOA, AOA, whichever class, other start பண்ணுவாங்க. What is MOA? What is AOA? What are the clauses in MOA? What are the clauses in AOA? Now, which overrides what? Between MOA and AOA. MOA is superior than AOA. But then we have section 6 which says Act overrides everything. So Act is first MOA, next then AOA. If there is a conflict, always follow Act. Unless the Act itself tells MOA is superior than me. Sometimes Act tells no, what is MOA, that is right, not the Act. So sometimes Act gives in some sections power to the provisions, we will go with that. Clear guys? So what is section 4? 5, 6, Act overrides MOA, AOA. Within 4 we have a provision called entrenchment provision. Let me explain that. What is entrenchment provision? Something which is more restrictive than special resolution. More restrictive than special resolution. More restrictive than special resolution, guys. This I can include in 2 ways. When a company is being incorporated, it can be included in my articles of association, or at a subsequent time I can include it in 2 ways. If it's a private company, you have to pass a unanimous resolution. If it's a public company, you have to pass a special resolution to modify or include my entrenchment provision. Are you guys following this? Section number 4, like this 5 AOA. So 4, 5, 6 over. Section 7, effect of documents. When you are incorporating a company, what all documents you will file with? ROC. Section 8, Section 8 company. Here provisions most of you know. Some key questions I will ask you, see if you are able to answer. Section 8 company, can I use the term private or public? No. Can Section 8 company declare dividend? No. Section 8 company, for it to start, it has to get what license from government? Special license from central government. If Section 8 company is not doing charitable work, then the license will be cancelled. Company will be ordered to wound up or amalgamate with some other Section 8 company. Section 8 company, sorry? Amalgamate some other company with similar objects. For Section 8 company, AGM notice instead of 21 days, it is 14 days. Are you guys following? Few key provisions in Section 8 company. Next is Section 9, we all like. Effect of registration. A company incorporated as separate legal entity, perpetual succession, buy assets, incur liabilities, be sued. You can sue all of that. Section 9. Section 10. Effect of MOA and AOA. What is this effect of MOA and AOA? It creates a relationship between company and members, members and company, members and members. In some cases, company has to pay to members when dividend. In some case, member has to pay to company, calls. Member has to pay the other member. What case? Rights, renunciation of rights. If it happens. Are you following? So a binding relationship is where a family, create from the Section 10. Are you following, guys? Section 11. Not that. Aduk we have Section 10A. Mark it as important. Commencement of business. From the time you receive certificate of incorporation, within 180 days, 2 things has to take place. 1, verification of registered office, and you have to do a declaration that the subscribers of MOA have given money for shares that have been allotted. Are you following, guys? Are you all with me? What is 10A? Important section. From the time of certificate of incorporation, within 180 days, two things have to be filed. One, verification of registered office. Next, declaration that subscribers of MOA have been allotted securities. Allotted securities, and they also gave cash, proof that they gave the money. So quickly we finish section 1 to 10 now. Are you following, guys? Remind me in the last 20 minutes what I will do. Two important things. Share capital and debentures. One or two procedures I will run through. Tell you how you have to read and what you should remember. Second, in our index in the book, if you see, in the starting, we have list of sections. So, list of sections. For each section, we will run through from start to end, and I will mark them as A, B, C category. A na important, you have to study. B is medium. C okay, less important. Don't expect lot of C's, guys. To the extent of importance, I will mark it for all these sections in the last. So it will be like a one-time revision of all these sections. And then I hope you guys also have seen this rocket notes which I have given, which will help you in revision in the ending. Meaning, sir, mostly we get confused in law. What is ordinary resolution? What is special resolution? What are the various limits? What all requires 447? All provisions of unanimous relevant forms. For about 30 pages I have created summary. All these requires ordinary resolution. You will go through for your revision. It will help you day before exam. What all requires? What are the limits? What all special resolution? Mostly will be here. Key summary table of deposits. What all requires fraud? 447. Unanimous, whatever is there, unanimous. Then various forms. Sir, form number padiknuma vana. But with form number you can see all time limits. See, deposits DPD3 filed within 30th June of every financial year. So all the time limits will come off here. I have given you time limit, buyback, within 3 days of completion of buyback in form SS11. You ignore form numbers, but at least all the time limits will come here. Are you following? So this you will do, read it after you finish studying for revision purpose. Clear? Let's proceed. We finished from section 1 to section 10. Of course, at this point, if you are a recording student who's watched till now, you have already survived to almost 75% of the recording. Before you click on description and go to iOS, General Class Act, Foreign Company. Understand, you spent 100 hours in whichever class you went to learn law, 80 to 100 hours. Then you spent another 30 to 40 hours in your house minimum to study by yourself. Again, you will spend that for exam. In one day, we are trying to revise the whole syllabus. Means it will feel overwhelmed. It will feel scary. No, it should at least tell you, okay, this is the syllabus. It gives you a structure as to what you have to do. Are you able to follow, guys? So this intention of this day is not for you to get scared. You will feel tired. No doubt about that. 8 AM to 8 PM, any class, anyone sitting is going to be tired. You will go home and sleep. That is normal. It's okay to go home and crash today. But the next day, whenever you are watching this marathon, guys, offline, online live or recording, whenever you guys are watching this, spend that full day. Within the next 1-2 days, ensure you revise everything at your end. That means today you spent 8 hours, another 16 to 20 hours from your side, 1 or 2 days, then law will fully be in your grip. Then you can move on to next subject. That means the next 2 days, you have to put full effort for law, forget other subjects. At least for us here, you guys have test on 7th of April, so you will study tomorrow and test, so it's beautifully planned. Others also, tomorrow, day after, somehow you study law, or sir, I'm writing tomorrow some other exam. Within the next 3-4 days, or full revision in law pantana, that's it. Nobody can stop you fully. At least for 75% you will be in control. Are you following, guys? Clear? Yes, being tired, everybody will be tired, but last 1 hour, let's push, guys, come on. Section 1 to 11 is done. Next is section 12. Okay. No more breaks after this, guys. We will end and then that's the break. Okay. Till 8 o'clock I am going to keep going, guys. 8 o'clock only I will do important sections. Okay. Fine. Those who are sitting in third floor and watching YouTube live, if you want, you can come down. Some empty chairs are here, but don't disturb the class. Slowly come and settle down if you are seeing. Okay. வரலனா அங்கே இருக்கலாம், பிரச்சனை கிடையாது. Okay. Fine. And again, I know it's getting late, so whoever is over here, recording ignore. If you guys have to get home, slowly without disturbing the recording, without making noise, you can go home. Later you can watch recording. Up to you guys. I will not ask you to stay till 9:30, 10 and all. We are not going till that time. Suma sonna. Okay. Okay. With today, even all my inter classes will come to an end. Finally, today my inter class gets over for May 24, all marathon, everything. Okay. Fine. I booked a night show movie for myself today. You are not going anywhere. There is some Malayalam movie booked. I think it's Premolu Rida Pora. Okay. Fine. புரியல ஹாட்ஸ்டார்ல வந்து கொஞ்ச நாள்ல my friends booked as வருதுறான்னு சொன்னா இல்ல I want to see in theater ன்னு சொன்னா சரி okay we'll go. Fine. Okay. Fine. Let's proceed guys. Small distraction. I told him after booking I told வேற படம் இருக்கு King Kong அதுக்கெல்லாம் போல இல்ல I want to watch this. They said okay fine let's go. You guys don't watch anything guys until exam. No problem. OTT ல வர போகுது. You can see in OTT. பாத்துட்டீங்களா good. Okay. Fine. Okay, next we finished till 1 to 11. Again let's revise. 1 is title, 2 3 minimum number of members, 3A unlimited liability, 4 MO, 5 AOA, 6 act to MOA, 7 incorporation of company, effect of documents, 8 section 8 company, 9 effect of registration, 10 effect of MOA AOA, 10A commencement of business, important, 11 not that. Section 12 talks about registered office. Let me take some key points here. Registered office should be a physical office, mandatory. It cannot be a virtual office. Sir, work from home. At least one bathroom size office you should have. Minimum. Physical office is mandatory guys. Next. Example, don't ask me what happened to the result. Okay. Next. Every place outside the registered office, the name of the company should be placed. Wherever company has branches, name should be there in English and vernacular language in small size for legible irunda podum. Then every letterhead of the company or fax company is sending or any email or post, whatever any company documents, company's business cards, the name of the company along with its address and contact details have to be printed. It's called labeling provision. Are you guys following guys? This is section 12. Section 12 also talks about shifting of registered office. Which page number? 41. Correct 41 no? Yeah. Shifting of registered office. So within the city, I am in Chennai. I want to shift from Annanagar to Nungambakkam. Don't have to ask the shareholder. Both can pass board resolution, intimate ROC in 30 days and go. Now intimating ROC in 30 days, section 117 varum. When you write this in exam, how you will write? Company has to intimate ROC within 30 days. Inform MGT 14 as per section 117. Are you following guys? You don't write intimate ROC in 30 days. 117 portion you bring it over here. Clear? Within the state, within Tamil Nadu, or let's say within Andhra Pradesh, from Vijayawada to Vizag, or within Kerala, Kochi to Calicut, then you need to get members' permission because members have to travel if they want to communicate with you. Pass special resolution in general meeting, intimate ROC within 30 days. When I pass SR, automatically BR comes here. So BR also will be passed and then special resolution. Clear guys? Because to pass SR, you need to keep AGM or EGM. To keep AGM, EGM, you need to pass board resolution. No? Correct? See, if you want to keep EGM, you have to pass board resolution. Where you will pass SR? In meeting. So in meeting, agenda decide, you have to pass BR. So technically speaking, every special resolution is pre-followed, prerequisite is a board resolution. Are you getting it? Okay. Next. Next, within the state, one jurisdiction to another jurisdiction, ROC to ROC. So within Tamil Nadu, let's say Coimbatore to Chennai, or within Maharashtra, Pune to Mumbai or vice versa. In this case, procedure is big, but I'll just quickly brief the procedure. and one state to other state, section 13. Very simple. In both the cases, first you have to go get permission of regional director, then regional director will give an order in both the cases. This order you will intimate to ROC, they will give you a new certificate of incorporation in both these cases. Are you guys following? Clear? In both these cases, what is common? You need to give some attachments to the regional director, like creditors have given the consent, then employees are not affected, then if there is any legal case, I will not shift the court. Are you following, guys? If there is any pending case, I will not shift the court. Both the cases common. Details of creditors, employees are not affected, legal case not shifted. Then these are common points. In the second case, one state to another state, you will also give additionally details of debentures of the company, latest data of debentures. Are you following? Time limit in section 12 is 30, 60, 30. That means you will intimate. No. You will intimate. So once you apply to regional director will reply within. I'll just write it. It's 30, 60 and 30. Once you apply to regional director, they will reply within 30 days and they will take a decision within 15 days. Once you get the reply, you will intimate ROC within 60 days. ROC will give you a new certificate of incorporation within 30 days. This is section 12. Same jurisdiction but ROC to ROC. Are they same section? 13. State to state. You will intimate RD. RD will reply within 60 days. Here there is no sublimit. State to state, now RD is given more time. Then once you get the reply within, you communicate to new ROC. New ROC will give you a certificate of. Here only common points is creditors, employees not losing job. Then legal cases are still pending. Here only additionally we write debentures. So what are that? Look at this point. These are common in both cases. Are no change of court, employees are not affected, payment to workmen is not affected, consent of creditors. But what is extra in section 13 is little additionally you have to give some more attachments, details of debentures. Where is that? Yeah, creditors and debenture list not later than 1 month. That is the latest list of debentures. Are you getting a copy, guys? Idea. Now section 13 is alteration of MOA. Because it's registered, registered office is being shifted, alteration of MOA. So now we finish section 12, registered office. Section 13 is what, guys? Alteration of MOA. Can you tell me the clauses in MOA? Name clause, situation clause, object clause, capital clause, liability clause, subscription or association clause. Following? Clear? Association or subscription clause cannot be altered because they are the first shareholders. How will I change that? You can't change the people who form the company. Liability clause also cannot be altered. Just now we saw how we can alter situation clause, section number 13. Capital clause alteration is section 61, alteration of share capital. Let's do quickly section 61, alteration of share capital. What is alteration of share capital? Increasing authorized share capital. Then consolidation of shares, subdivision of shares, conversion of shares to stock and vice versa, cancellation of shares which are unissued. Correct? Now for these four things you have to pass an on resolution and general meeting. What do you mean by consolidation? 1 lakh shares of 10 each becomes. So consolidation. 1 lakh shares of 10 each will become 10,000 into 100. Just checking. 1 lakh into 10 becomes 10,000 into 100. What is subdivision? 1 lakh into 10 becomes 10 lakh into 1. Increasing subdivide, consolidations together. Why do I do subdivide? Why do I increase the number of shares? To create, to reduce, when there is a demand, to reduce the demand, to create supply. It's like if you increase number of shares, supply is increased, then price will come down. When I will do consolidation, to create demand, reduce the number of shares, so price will go up. Nowadays they are asking questions like this. I have seen RTP, company wants to create demand, what they should do. Are you following? Only for increasing authorized share capital you will pass, because it's alteration of MOA. Next, alteration of object clause. Can you alter object clause? Yes, by passing special resolution, but the effect is only prospective but not retrospective. Are you guys for prospective effect of alteration? Name. Can company change the name of the company? Yes, by passing special resolution. Here only I told reservation of name. We discussed in LLP. New company means old company means. So you will reserve the name. After passing resolution, within that time you will get the new name. Are you following, guys? Private limited company should use the word private limited. Public will use the word limited. OPC should use the word OPC. Section 8 company should not use anything. They will use club, chambers, association, all of this. Are you following, guys? Now, this is object clause. Clear? This is section 13. What is section 14? Alteration of. Already entrenchment provision we saw. In alteration of AOA, we can do one more thing. Alteration of AOA, two things. Private limited converted to public converted to. For both you have to pass what resolution? Special resolution. Only one of this has central government approval. Can you guess which? Public to private. Public money becoming private. So I need here additionally central government approval. Are you guys following? Then you will pass resolution, do necessary filings. That's it. This is section number 14. Section 15. Now again come with me. What is section 13? Alteration of MOA. Section 14. Alteration of. Now after giving you material, sometimes I make some changes. I have to make change in all books. That means I have to communicate to you in some way. Like that before, if company is doing alteration of MOA or alteration of AOA, such an alteration should happen in all copies. That is section 15. Are you following, guys? Section 16 completed, yet to do. Panni mustome. LLP, rectification of name within 3 months or new company 3 years. You remember, guys? Hello, Nabarka. Trademark within 3 years from date of incorporation. LLP, it's section number 17. Here section number 16. What is section number 17 here in Companies Act? If you want some documents from the company, copies of agreements under section 117 or MOA or AOA, you will request the company. Company has to give it to you within 7 days. Otherwise, penalty is rupees 1000 per day. Are you guys following? Yes, section 17 answer earlier. 117, not documents filed under 117 if you want copies. Resolutions and agreements filed in 117 if you want, you can apply in section 17. Answer is 7 itself. They will give it to you within. Otherwise, penalty of 1000 per day. 17. Are you following, guys? Clear? Okay. Next, section 18. Conversion of company already registered. Private to public, public to private. Can you convert a company to section 8 company? Can a private or public be converted to section 8 company? No. Section 8 company has to be newly incorporated, getting a license from central government. Special license. Are you following, guys? Next, section 19 is what? Subsidiary company cannot hold shares in holding company. Not allowed. Because if both of them have shares in each other, then who is the holding? I will not know. It becomes a confusion, but there are 3 exceptions. Already has some shares before relationship was established. For example, holding subsidiary. Holding has 70%, but before holding got 70, I already had 25%. Such 25% will be continued to be kept. Already had shares. Next, as a legal representative of the deceased, legal representative of deceased shareholder, or in the name of trustee. 3 points important. Section 19 exceptions. Subsidiary company cannot have shares in holding. Section 19, subsidiary cannot have shares in holding. 3 exceptions. Already I have those shares. Second, legal representative of the deceased. Last, I have it in the name of trustee. Are you guys following? Any doubts till here? Again I will repeat. Subsidiary code of shares and holding. 3 exceptions. Already have shares. Legal representative of deceased. Having the capacity of trustee. That is section number 19. Last 3 sections incorporation chapter will be done. Section 20, 21, 22. 22 is simple. Authentication of negotiable, execution of negotiable instruments, bills of exchange, promissory note or check. Who has to authenticate? It has to be authenticated by first using a company or a common seal. Sir, seal illa sir, I don't have seal. Then CS plus 2 directors. No, CS plus 1 director. Sir, no CS. Then 2 directors. Are you guys following? Just checking if you are all awake, guys. Come on. Okay. So section 22, execution of negotiable instruments authenticated by common seal. Common seal not there. CS plus director. CS also not there. 2 directors. Same section 22. Copy paste section 46. What is 46? Issue of who has to authenticate share certificate? Ideal. So share certificate also is authenticated by common seal. No common seal. CS plus 1 director. No CS. Then 2 directors. Are you guys following? Yes. Any doubts still here, guys? Section 21. Who can use this common seal? Who can authenticate documents of the company? KMP can authenticate. What do you mean by documents? Rental agreement. Some contract companies entering. Only it can be authenticated by KMP. Are you following? Section 20 is serving of notice. We have 3 people. Who are those 3 parties here? Company, ROC, members. Sometimes company has to send some documents to members. Members have to send to company. Sometimes company has to send to ROC. ROC will send to company. ROC and members we don't have. No, not much direct communication. So here, in both the cases, in both ways, what are the allowed methods, guys? Look at this. In both the cases, ROC to company or company to ROC and members, registered post, speed post, courier, leaving it at the registered office or electronic mode. What do you mean by this? I will go and leave it at the registered office space or electronic mode. But only one thing, company to members, same. If any member mattu says, send it to me in WhatsApp, then I will send in WhatsApp, but I will pay the fees which is required for that. In e-mode, there is a clarification saying which e-mode, sir, Instagram okay va, Telegram okay va. There has to be a proof of document, the message or document being going. You should not have the provision to delete it. Some evidence should be there. Are you following? Mail, once you send, you can't unsend it. Sir, I can send few seconds. So there is a proof of electronics, then only it is allowed. That's why they don't allow WhatsApp or Instagram. We have provision of delete. Are you following, guys? Clear? Then what is this, sir? Nidhi company, there are some exceptions. You go through the book. Nidhi company, what are the exceptions? This is one. In section 127 also, in dividend we have a Nidhi company exception. I would have given in the book. What is that? I'll finish both of that now. Here they are saying for Nidhi company, serve the document only on members who hold more than 1,000 in face value or more than 1% of paid up share capital, whichever is less. No need to send to all members. Only if they follow this limit, I will send that document. Are you following? For other shareholders of Nidhi company, document may be served in public notice in Matangla. I won't send 1-to-1. No need to waste money. You are investing 100 rupees. Post I will put in newspaper. You see. Are you following, guys? Clear? This same section 127 says, in a Nidhi company, if the dividend payable to the shareholder is less than 100, I don't have to pay dividend to him within 30 days. For dividend in Nidhi company, dividend payable if it's less than or equal to 100, check. Less than 100, dividend should be paid within 30 days. In I will keep in company notice. That notice will be kept in the company notice board for 3 months. நீ வந்து வாங்கிக்கணும். நீ dividend 10 ரூபாய் நான் ஸ்டாம்ப் 5 ரூபாய் வாங்குவாங்க. Are you following, guys? So two nidhi company exceptions. One is in section 20, one is in 127. If the examiner wants to irritate us, he will ask this. Okay. Clear, guys? This. So incorporation chapter 1 to 22 is done. Are you following? Perfect. Okay. Let's go to prospectus. Prospectus chapter starting from section 23. We can go on to 42. Then I will do 1-2 procedures. Maximum cut off 8:30, guys. 8:30 I will close. Maximum. Okay. Fine. See, I can close now also. I have nothing for me. But we can cover a lot in this 1 hour. Okay. Fine. 23 is what, guys? Who can issue prospectus? Who can issue prospectus? Let me use the book for this. I will discuss only key provisions in prospectus, guys. Let me discuss important sections. Who can issue prospectus? Follow. Public company in the following cases: public offer, private placement, rights or bonus can issue prospectus. Private company, they can do all of this except public offer. Are you following? Then in prospectus chapter, definition of the term security is important. Run through the definition of the term security once. What is a security? Shares, scrip, stock, debentures, derivative, units of other instrument, any units issued by any collective investment scheme. Just be aware of these terms. No time to explain what it is. Security receipt under SURFACE Act. Then there is some government security. All these are securities. Which is important for MCQ? This one. This is important for MCQ. They will ask. Security shall not include any unit linked insurance policy or scripts or any instrument or unit by whatever name called, which provide a combined benefit of risk of the life insurance type of policy. Unit linked insurance policy is not a security. MCQ sometimes they will ask which of this is not a security. Are you guys following? This is 1 point. So we are done with section 23. 24. What not there? It's there. Which is that page? New additions in Act. What is that, guys? New additions. Page number 1. New additions, guys. See the index. 2. Yeah, got it. New additions. Sorry, I have a separate chapter. Correct? You have it, guys. For you guys, I have given handout. Handout, who has it? Handout is there. Fine. Don't tell I didn't give. Okay. Different book days. Okay. Fine. அந்த புக் உனக்கு எப்படி கிடைச்சது? ஓ இங்க இருந்ததா? ஃபைன். ஏதோ ஒரு புக்ல இருக்கும் guys. Fine. புரியல. Not my what do. Fine. அது photo editing பா. நான் அதுவும் பண்ணல. Like section 24, regulation and issue transfer of securities. Let me finish off this new additions, secret additions in this Companies Act. Now 24 is simple, guys. For listed company, SEBI is saying na paathukken provisions like issue and transfer, non-payment of dividends, all matters for prospectus, everything I will take care. Not that relevant. Clear? Next to new addition. New addition are not removed from ICA syllabus. Section 30, advertisement of prospectus. You already know. Don't read the section. What are the clause of MOA? Name, capital, liability, object clause, all of this. When you give advertisement of prospectus, give details of all this clause. Object, liability, amount of share capital, signatory clause, capital structure. MOA clause no disclose pannu. Are you for what is MOA clauses? Section number 4. Clear, guys? That is section number 30. Section 33 important. Abridged prospectus. Abridged prospectus you can easily remember. That is the first section in Companies Act. Section 2 subsection 1. That is first definition, guys. AB. Abridged prospectus. It's a shorter version of prospectus. In what case abridged prospectus is not important? Not needed. So every application of the issue of shares or debentures needs abridged prospectus except in the following cases. 3. Underwriting rights and shares or debentures not issued to public. Now 42. Private placement. Are you guys following? So you don't need abridged prospectus in underwriting cases. Rights issue or not issued to public. Are you guys following? Do you remember doing this, guys? Okay. Similarly, prospectus chapter next. GDRs not that relevant. What is GDR? I have explained over here. You read that. But for GDR issue, you have to pass a special resolution. Are you guys following? This paragraph I didn't type, guys. I used ChatGPT. What is GDR? ChatGPT I edited. I am using AI in class. Okay. Fine. Follow. Okay. This one thing I took from ChatGPT, but I made some edits. Okay. Next. Fine. Section 34. 34. This is important, guys. Oh, yeah. Change it to section 38. Thanks for correction. Printing issue. Section 38. Okay. Follow. Okay. Now, let me finish these sections. Then I will do rest of prospectus. We will go in full speed over there. 38. Follow. New section again. For you to get shares, sometimes people will do multiple applications. Sir, college line seat meno, sir. You will do send 10 applications. You will keep changing your name in different way. Maniraj. First application Maniraj. Second application money.r. Third application Raj Money. And why you will keep changing. Next application is only money. Next application is only Raj. Photo light up with hair, without hair. He will apply. Okay. So on the money, if you do punishment for personalization for acquisition of, if you are changing your name and photo for getting shares, if company finds out, then you are liable. So basically, allotment of shares is not allowed if you apply in fictitious name to the company, applies in multiple applications, in combination of his name and surname, directly or indirectly induces company to allot or register shares to him in a fictitious name. Let's say he puts Barbie doll application, so I will see and I will give it, and my money Barbie, and my photo. Okay, fine. Or in fictitious name, money Dhoni, and my if he puts. Okay. In simple words, using dummy identity to get shares, you are not allowed. Are you following it? That is section 38. Consequence of above registration, the person getting allotted in fictitious name is liable as a. The court may order for disgorgement of any, and the share and the cash and they will transfer to IPF. Are you following, guys? What money will get? Nothing. Okay. These are the new additions in prospectus chapter. Charge already panitoma. 95 also we did. 41 is GDS. I told you how to pass a special resolution. Okay. 24. Just now we saw. SEBI takes care of everything. 25. Let me discuss all the types of prospectus. Prospectus, the last two important areas. Types of prospectus. We have 4 types of. One is 2 subsection 1 plus section 33. Abridged prospectus. 33 is when you should not issue prospectus. Next. 25 we already saw. Next. 31. No. 31 is shelf prospectus. 32 is. What are the key provisions in each of this? 2 subsection 1 abridged we just now saw. Not made in which case? Rights issue, underwriting and private placement closed, not a public issue. Deemed prospectus means I will come to it later. Shelf prospectus, key provisions, guys, key provisions. Shelf prospectus is applicable in case of infrastructure companies or companies which is recognized by SEBI. Over here, such a shelf prospectus is valid for how long? 1 year. During the 1 year, you can make multiple issues. But the 1 year starts from the date of first issue. Whenever I do the first issue, from that day only 1 year starts. Can a member pay money in advance, calls in advance? Yes. If he pays calls in advance, I will refund if he asks me. Okay. Refund within. Refund in 15 days. We don't know. Refund. Next, before every new issue, you have to submit something called information memorandum. So, before each issue, you have to give an information memorandum which gives updates about material changes from the time of the previous issue of prospectus. Are you following? So, how do we remember 1 year? 31. 1 stands for 31, 32, 33 is prospectus. 31 is shelf. 32 red herring prospectus. 33 abridged prospectus. So 31 is shelf prospectus. Are you guys following? Clear? Understanding, guys? So 1 year from the date of valid for 1 year. Money given will be refunded if you ask within 15 days. Before every new issue, information memorandum 30 should be given, at least issued 30 days in advance. Red herring prospectus. What is red herring prospectus? A prospect is like a bait. Red herring, the word red came from a fish called red herring fish. Okay, don't write that in exam, fish, no? In exam, red herring prospectus should be filed at least 3 days prior to opening of. So the exam MCQ, there is nothing else to ask in red herring prospectus. Before opening issue, it has to be filed 3 days before. Red herring prospectus is a prospectus where number of shares and price per share is not known. Only the total quantum of money I want to raise is disclosed. So total quantum I want to raise is disclosed. Number of shares and price per share is not available. Lastly, deemed prospectus. So prospectus has lot of provisions to comply. So sometimes what companies will do, let's say Adani is entering into an agreement with Badani. Badani is issuing shares to public. Whose shares they are issuing to public? Adani shares are given to public. Now Adani is doing this to escape the provisions of prospectus. So this agreement will be called a deemed prospectus if this agreement Badani has not paid, after allotting shares, they have not paid full consideration. Let's say the number of shares Adani wants to issue to public is 10,000 crores. Full 10,000 crores should have been paid by Badani. If they have not paid the full consideration, then this agreement becomes a deemed prospectus, and also within the or within 6 months of Badani getting the shares, the 6 months shares are not issued to public within 6 months. So either shares are not issued by Badani. This Badani is called issuing house. Adani is my company. So what is a deemed prospectus in section 25? Where a company enters into an agreement with an issuing house for allotting shares, and such agreement with the issuing house was not given me the full consideration, or that shares by the issuing house is not given to public within anyone not satisfied, then it's called a deemed prospectus. Within issue within, correct, within 6 months. They should have issued within 6 months. They should have issued within 6 months. If they issue after 6 months, then only it becomes a. No, see, if they issue in 9 months, what is it? Not a deemed prospectus. Deemed prospectus. Tell the page number. Okay. So, company enters into agreement with allottee issuing house to transfer securities to the public, and they are issued to public within 6 months from the date of agreement, or the allottee has not paid full consideration before offer of sale. Such agreement will be a deemed prospectus. That means once you issue to them, they are issuing within 6 months. Logic over here is very simple logic. Immediately after issuing to them, they are issuing to public within collecting the money and giving the money over here. That's why full consideration is not paid. I can't pay full consideration because I don't have the money. So quickly within 6 months you will issue to public, get that money and give it to Adani. That's why they are saying either full consideration is not paid, or if it's issued within 6 months, it's called a deemed prospectus. Are you guys able to follow this section 25? So we finished 4 types of prospectus. 2 subsection 133 is abridged prospectus. 25 deemed. 31 shelf. Next 32 rendering prospectus. Next we will go straight away in this chapter. Let me go to 34, 35, 36, 37. What is 34? Very important in this chapter. Criminal liability. 35 talks about civil liability. 36 talks about, what is 36? Fraudulently inducing persons to invest in 3 cases. We will come to that. And 37 is class action suit. Now in 34, what they are saying in 34, if the prospectus contains any misstatement where the statement is omission of anything material, or you are having a misleading statement or omission of anything material, then whatever loss is there, the particular parties who have signed it, they will be criminally liable. Are you guys following? They are criminally liable. Next, what is civil liability? All the loss have to be compensated by these parties. Are you following? So if I go to that part, okay, so they are saying omission of any matter which is misleading, or any person includes any statement which is misleading statement or omission of any statement, then that person who was authorized is liable under section 447. When he is not liable, if he tells it is immaterial, or he can prove that the statement was true, or he believes that omission was necessary. Same misstatement, 447 is imprisonment and penalty will come. Civil liability 35 says you will compensate to everybody. All the people who signed here will compensate to the person who suffered loss without any limitation of liability, unlimited liability. Are you guys following this, guys? Okay. When you are not liable, if you knew about this, director withdrew his consent before issue of prospectus, or issued without his consent, or once you knew a person's prospectus was issued without person's consent, becoming aware, you make a public notice that my consent is not given. Or if you rely on the expert, person who made the statement based on rely of expert, I am not liable, I rely on expert, only expert is liable. Or if you believe it's true and thought it's true until the issue of shares and allotment. Are you following, guys? Now 36 talks about 3 things. This you mark it as important, guys. Punishment for fraudulently inducing person to invest in money. Here they are saying obtaining credit facility from bank, or if somebody is calling you and telling take this EMI, take this loan, it's good, fraudulently inducing you, then it becomes fraudulently inducing, or entering into underwriting agreement, or securing profits through sale of price fluctuations. I am telling buy this share is very good, price will go up, price will come down. Telegram group they will tell all the members buy this share, price will go up. And if you do means, then those people are liable for fraud. 3 unique different cases: bank facility, underwriting, or profit fluctuation. In all these people, everybody affected can file a case together called 37 class action suit. Are you guys following? Now section 39 and 40, let me quickly ask you a few points. Allotment of securities and application to be dealt in stock exchange. Let me be a question answer session. 39, allotment of securities. Allotment, minimum application money should be 5% of nominal value. Subscription minimum is 90%. Allotment should be done within 30 days. If not, refund in 15 days. Interest is 15% from the 46th day. Are you following, guys? Allotment of securities. 40 talks about application to be dealt in stock exchange and underwriting commission. You have to apply to stock exchange for getting permission. If you don't get permission, allotment becomes void. Underwriting. What is the commission for underwriting? Shares and Debentures. Shares is 5% or rate in AOA, whichever is lower or higher. Lower. Maximum is 5%. Debentures is 2.5% or AOA, whichever is lower. For paying the underwriting commission, can I use profits for paying? Yes. Can I use proceeds of issue for making payment? Yes. This is section 39 and 40 key points. Are you following, guys? Now, we'll go with this prospectus to an extent we have seen. Also make note of section 27. Variation of terms. Last section, let's take. What do you mean by variation of terms? If after issuing prospectus I raised 100 crores, I used only 80 crores, 20 crores is unused. Can I use this for some other purpose? Yes. Changing the object. What is the procedure? Company has to first pass special resolution and postal ballot, because postal ballot section says section 27. Then publish in website and newspaper. Remember, whenever I say newspaper, it is two newspapers, one English, one vernacular, having wide circulation. Then next here, explanatory statement, because it's a special business. Explanatory statement. Then exit opportunity to dissenting shareholders. That's it. 27 procedure in one line. Try to make summary notes. Special resolution and postal ballot, website and newspaper, exit opportunity and explanatory statement. Are you guys following? Clear? Able to revise, guys? Now we will go to some procedures. I will just take maybe one or two procedures. How do you remember procedures? For example, if I take 42, 43, rule 4, which talks about differential voting rights. Can I have one share with 20 votes? Yes. If you pass this procedure. If you look at the procedure in book, page number 61 now. Okay. Now, procedures might be big. How do you summarize this? Just to show everybody how do you do it in simple. First they are saying articles have to authorize. So I will write articles will authorize. How do you remember for exam if you already have these notes? Next, company has to pass OR in general meeting through postal ballot. Adhe line I will write. Company will pass on resolution in general meeting using postal ballot. Next, maximum 74% of the issue, post issue, maximum 75% of post issue can be differential voting rights. Then if you see here, they were given 3 years some condition and 5 years some condition. So last 3 years, last 5 years. Under last 3 years, there are two things that you should not have default in section 92 and 137, filing annual return or financial statement. At the same time, not defaulted in few acts like RBI, SCRA, FEMA and SEBI. RBI, SCRA, FEMA and SEBI you should not have defaulted. So last 3 years no default in 92 and 137, RBI, SCRA, FEMA and SEBI. Last 5 years, whatever payments company have to do, if you read this, all the payments, no default in dividend, deposits, preference shares, loans from banks, employee statutory dues, IEPF, all of that. So in simple, all the debt borrowings, all the equity plus dividend plus interest, none of these should have a default, plus employee dues plus 125 IEPF. Then you will see some more points like, then explanatory statement is 102, board's report should give details 134, maintain details of register in DVRs 88. So I will write 3 more points over here, 188, 102, 134. That means company has to maintain register of members for DVRs, 102 explanatory statement, 134 disclose in board's report. Then last 2 more points, existing shares cannot be converted to DVRs and all the other rights are pari passu. That means all the other rights like bonus etc. is pari passu. So big provision, we just summarized in 3 to 4 lines. How do you remember this? Company has to have authorization in Articles of Association, order resolution in general meeting. Maximum 74% of post issue can be DVRs. Company should last 3 years, no default in 92 and 137, no default in SEBI, SCRA, FEMA and SEBI. Last 5 years, all the debt equity has been paid, employee dues and no 125, 88, 102 and 134. Register of members, explanatory statement, sign details in board's report. Existing shares cannot be converted to DVRs. DVR cannot be converted to existing shares. Pari passu. All other rights are same. Like this, if you write notes, you will easily remember day before exam. Let's take another procedure, buyback. 5 minutes we can complete buyback. Biggest procedure that we have is buyback. For buyback, if you remember our notes, I will again recreate them quickly here in 5 minutes. You can pass board resolution or if you pass board resolution, buyback is 10%, special resolution is 25%. Also, the maximum buyback resources to be used cannot exceed 25% of paid up share capital plus free reserves. For the purpose of this section, free reserves also includes securities premium. And again, third point, 1, 2, 3, debt equity ratio post buyback shall not exceed 2:1. Next, once you pass the respective resolution, buyback should be completed within 1 year. Within 1 year. So this is the date of completion of buyback. Now once you complete buyback, what are the time limits? We have a 3 days time limit. We have a 7 days time limit. Within 3 days, what is it? Within 3 days you will inform ROC, return of buyback. Within 7 days you will destroy the share certificate. Within the next 6 months, company should not make no fresh issue of shares. Exception, why no fresh issue? இப்போ தான் buyback பண்ணி திருப்பி காசு எதுக்கு வாங்குற? No fresh issue. The exception here is bonus, ESOP, convertibles. Are you guys able to remember, guys? Perfect. Now you look at the Gen Z notes. That's the idea of doing this to get confidence. And then after completion of buyback, you should also no buyback for next 1 year, and also next 1 year declaration of solvency. That's it. What is the procedure, guys? Very simple. From the date of passing resolution, which resolution? Board or special resolution? Board resolution means 10%, special means 25%. Maximum buyback is 25% of paid up share capital plus free reserves. Free reserves includes securities premium. Debt equity ratio of post buyback should not exceed 2:1. Once you pass resolution, complete buyback within 1 year. After completion, look at the time limits. 3 days, 7 days, 6 months, 1 year. Again, 3 days, 7 days, 6 months, 1 year. Within 3 days, file return of buyback to ROC. Within 7 days, destroy the share certificate. Within next 6 months, no new fresh issue except bonus, ESOP and convertibles. Next 1 year, no buyback. Next 1 year, company should not be insolvent. Declaration of solvency. And once buyback offer is given to shareholders, within this 1 year, they should accept the offer within 15 days or maximum 30 days. Idhe for rights it is 7 to 30 days. Less than 15 days is possible if you get consent of members in unanimous. Are you following, guys? Clear? Unanimous, correct?
Yes, sir.
Okay. So when I give the offer to members for buyback, they have to reply to me within 15 to 30 days. Less than 15 days if I have a unanimous resolution. Same thing if I give offer to rights in section 62. Members should confirm within 7 to. In this, company can decide minimum 7, maximum 30. 68 we finished in just few minutes. So because of the Gen Z notes, how many of you have that? You should be having 68 na class la panna. You copy pannadha irundrum. Are you following? Clear, guys? Everybody understanding? Recording students, make a note. Like this recording, those who are watching, 43 rule 4 if you make notes. 68 if you can make notes like this, it is going to help you in revision. Otherwise, day before exam, adhe book 3 per Chennai use. You have to simplify it for yourself. Let's take one more procedure. Last one, 42. Private placement. Private placement. First, maximum I can give private placement for how many people? 200 people. Within this 200, this 200 is not applicable for. In this 200, you will not include qualified institutions. Not include QIBs and ESOP. Limit of 200 is not applicable for NBFC and Housing Finance Company, Bank. Next, 200, one more point. Limit should be applied individually for each security. Debentures 200, preference 200, equity 200. Amendment over here. Okay, I will come to the amendment later. So 200 related points are this. Correct? Only these guys. Anything else? Maximum in a financial year. In a financial year, private placement section 42 says you can give it to 200 individuals. That 200 individuals does not include, for the purpose of counting 200, QIBs and ESOP I will not count. And individually for each security, not applicable for NBFC and Housing Finance Company. They can go and issue with any number of, more than 200 also is possible. Sorry? Yeah, it's more than 200 means it becomes a public issue. Now what about the time limit? First you identify persons. The minute you identify persons, you have to give them offer within 30 days. Once you give them offer within 30 days, you have to intimate ROC within 30 days. This is in form PAS 4, this is in form PAS 5. Again, once you identify a person, give them offer within 30 days and then again intimate ROC within 30 days. Once you give them offer, you will wait, and once they give you the money, they can give the money anytime. Once they give you the money, you have to allot within 6 days. Allotment within 60 days. After 60 days of allotment, if you allot in 15 days, you will file return of in form PAS 3 to ROC. You will file PAS 3 return of allotment to ROC. If you don't do allotment in 15 days, you will refund interest. I told in the start of the class, interest at 12% from the not 76th day, from the 61st day. Now this money amendment is money should come only in banking channels, and another amendment here is if the money is coming from neighboring countries, border countries like Bhutan, Nepal, Myanmar, Bangladesh, they gave some list of some countries, then they have to follow FEMA regulation. Now understanding money laundering. Are we following, guys? So private placement we finished. No, for private placement, no form of public advertisement is allowed. Are you following, guys? Again, let's revise the whole thing once. For maximum private placement is for 200, section 42. 200 does not include QAB and ESOP. 200 limit not applicable for NBFC or Housing Finance, and the 200 is applied individually for each security. Then you identify people. Once you identify people, give them offer within 30 days in PAS 4, inform ROC in 30 days in PAS 5. Once they give you money, allot within 60 days. That money should come only in banking channels, and once allotment is over, intimate ROC within 15 days in PAS 3. If you don't allot, refund within 15 days at interest at 12% from the 61st day. No form of public advertisement is allowed. What resolution for this? Special resolution for private placement. Such resolution is valid for 1 year. Clear? Perfect. Following, guys. Resolution is valid for 1 year. In that 1 year, you can do any number of private placement issues. Like this, now I did for 3 procedures. 42 private placement. 43 rule 4 differential voting rights, and we did 68 buyback. Like this you still have for 54 ESOP. Let me ask quickly 3 questions or 4 questions in ESOP. ESOP once issued, lock-in period is? Yes. Super. Then ESOP, we still have the same 88, 102, 134. When I say it does 88, 102, 134, register of members for ESOP. 102 is explanatory statement, 134 board report. Then the limits for ESOP. We have 50%, 25%, 15% or 5 crores or 50 lakhs. 5 crores, whichever is higher. What are these percentages? The maximum sweat equity shares you can give is 25% overall share capital of the total paid up share. Maximum sweat equity shares in my share capital can be 25%. If it's a startup, it can be 50%. But in each financial year, you can issue only 15% of the paid up share capital or 5 crores, whichever is higher. We did sums also over here, I guess. Are you following, guys? Clear? I'm just revising a few points. Are you able to follow, guys? Okay, fine. So, with this, I think we have completed easily about 70 to 75% of syllabus. Recording students, nothing to worry. Interpretation of statutes, general class and foreign company. Tonight or tomorrow morning itself I will upload. All that put together. Interpretation of statutes and GCA is 3 hours. Foreign company is 2 hours. Recording will be on YouTube. Marathon only. You can watch it whenever you want, or if you don't, your choice. Whatever works for you. But today is to just tell you 1 to 2 days if you put the fullest of effort, you will be able to revise. Are you following, guys? Clear? Now I'll just mark those important sections. You mark it as ABC. Fine. I think next time we'll plan marathon 2 days. 1 day corporate law, 1 day other laws. புரியல நீங்க வர மாட்டீங்க, நான் சொல்றேன் ஜெனரலா. ஓகே ஓகே fine. Was it of any use, guys, whole day? Perfect. Let's start marking sections. For 1 and 2 is definitions, leave that. In definitions, 2 subsection 85 small company is important. For limits, 2 subsection 40 financial statement like cash flow exemption is important. Okay. 269 is the promoters, public company, prospectus. There are no limits over there. Okay. Foreign company, yeah. 2 subsection 42. What is a foreign company? Important when you will see foreign company chapter. Okay. Next. MOA. Okay, I am classifying in ABC, guys. Formation of company C. So what is it? Minimum of 3 and 7. Okay, fine. Foundation. MOA B. Articles B. Act to override MOA articles B. Incorporation of company B. Charitable objects A. Effect of registration B. Effect of MOA articles B. Commencement of business A. This will take 5 minutes and then we will close. Registered office of the company B. Alteration of memorandum A. Alteration of articles A. Alteration in every copy C. Rectification of name A. Copy of memorandum to be given to members C. Conversion of company C. Subsidiary company not to have shares A. These 3 I will keep it as B. Okay. This chapter is done. Can I go to the next one, guys? Yeah. It's just ABC analysis, guys. At least A mattu skip panadinga. Okay. Next. Public and private placement 23. Who can issue prospectus? B. 24 is C. 25 deemed prospectus B. Contents of prospectus B. Variation A. Variation is A. 28 offer of a sale is B. DMAT 29 means every share should be in DMAT. That's it. 29. That also I'll put it as B. Advertisement of prospectus C. Shelf prospectus. Yeah, we will put A. Red herring B. Issue application form. This attempt you can put it as A because of that red herring abridged prospectus first time inclusion. Criminal and civil liability, no doubt A. Next, punishment for fraudulent, I will keep it as A because they have never tested section 36. 36 test panla, worthy of 3 marks, put it as A. Class action suit C. Personalization again, new section B. 39 and 40 I will keep it as A, GD as B. Actually, CA you can keep. Okay, fine. Or C, new one, no, we'll keep it as B, guys. Sorry. Private placement, I will keep it as B because they tested in November 23. November 23 they tested private placement, so I'm keeping it as B. Otherwise, A. They asked for 6 marks, correct? 6 marks, so they may not ask that. DVRs A plus. Kinds of share capital B. DVRs they have never tested in any exam. Rule 4. Under 43 rule 4. Just now we saw no. It's a dead section now, but then you can keep it as A actually. But they can test it. It's a good procedure that they can test. Today not allowed because SEBI doesn't allow it. 44, 45 are not there. I just took the bar actor. 46 put it as B. Voting rights B. Variation of standard rights you can put it as A. Then 49 to 52 I'll put everything as B. Issue of shares at discount is just 53 and 54 again I'll put it as A, guys. Okay. 55 also A. 56 to 59 C category. Transfer and transmission 56 to 59 is C. Okay. 60 is not there. Okay. 61 A. It was tested 2-3 times in old syllabus. Again we are restarting questions, so I'll put it as A. 60 to 70 is very important. Most of them are A. 62 rights A, 63 bonus A, 64 B notice, 65 not there, 66 A reduction, 67 A, 68 buyback A, 69 transfer to CRR A, prohibition of buyback is A, debentures just now we did A, power to nominate we don't have. So 60 to 70 you have, most of them are A category sections. Okay, following. Can I go, guys? Next step. Deposit 73 is A, 74 or the CN put guys. Okay, 75 not there. 76 A, 76 A you put it as B. Remember the penalty. What are all the penalty sections that you can at least attempt to remember from starting 42, 447, 127, 86, 76A, 132, 147, 135. Correct, this is what I told. Now you do penalty. No. Not that important for penalty. Penalty, bare minimum 42, okay, last time kept, now you can leave it. At least 127, 447, 86, 76A, 147, 132, 135 are different types of CSR. 3 foreign company, add 392. Penalty foreign company, new one 392. At least penalty anyway, but at least in the 7-8 sections you can remember for penalty, bare minimum. Section 8, not much. LLP you can remember section 9 of LLP, designated partner penalty. They asked an RTP, they didn't ask the penalty actually, they asked MCQ. Okay, fine. Can we proceed, guys? This is now registration of charges. 77 is A, 78 A, 79 A. Charges is easy chapter, guys. Okay, date of notice again A. This 81B. Satisfaction. I am putting everything A because don't skip this chapter. It will take only 1 hour to read this chapter even first time. Minimum you will get 5 to 6 marks. So the effort you put in this chapter is very minimal. Intimation is B. This is A because it's a new addition and we have 2 new points. Preserve it permanently, all of that. Punishment I already gave it in 86. Rectification you can put it as B. So chapter itself you can put it as important. Don't skip. Because of the quantum is so less, easily you can learn, and definitely one question will come in charge or deposit set or 7 to 8 marks will come. Easy scoring area. Okay. Management administration, register of members B, 8990 you put it as A guys, because they have never tested again BO and SPO test pannadilla. 91 you put it as B, annual return is A. 93 not that. 94 B, register C. C getting 95 is C. 95 is there. Not for me. New learning. Okay. That technique is not good, huh? Not there. No, but that you learn section saying not there. Now I told later there. Technique is not good, huh? Mana on the technique. Mana on. Okay. AGM A. But I gave a separate handout for that, no? Okay. Power of tribunal to call AGM and EGM, you put it as B. Punishment C for a thing, and EGM you can put it as B. Now from here 101 to 105, actually till 110, everything is A guys. 101 to 110, everything is A. 111 and 115 is A. 112, 113 is B. 114 and 117 taniya kekka matom. It's not a separate section, it's part of your answer. Okay. So this part is important guys. A. One thing will come from here. Without a doubt, every attempt has something, one 6 mark or one 5 mark MCQ. Can we proceed guys? 116 you put it as B guys. And another one line portion now. Correct. Here 120 is C, 122 is C. Report on AGM you put it as A because not tested. Because it's not tested, I'm putting it as A category. Minutes both you put it as B guys. They tested recently I think minutes. 118, 119. Dividend la onume illa perisa, you put the whole chapter as A. Okay. Again dividend is a scoring chapter. Dividend, charges, less effort, lot of confidence. Okay. Books of accounts, first CSR 135, you put it as A plus. Still, they asked even last 2 times. They asked in November 23 and May 23. Still lot of amendments, so they may ask again. Lot of untested areas. Books of accounts, B, FS, B. NFRA, see, I can't tell you put it as B guys. Cost auditing irukku. You B protocol. Okay. 133C, 134A, 136. These are all A sections. These are all important. Weightage is high for books of accounts auditors. Mandatory question chapters. Or these 4-5 they will ask. See, in accounts of companies, one question on limits will always come. So wherever there is a limit, you can't tell it's B. Limit full syllabus 10 or 12 places. So every limit question is a category question. Okay. 130, 131. No, put it as A guys. See, put it as A. Auditors. This time you put 144 as A. Again, first 3A guys. See, that's why I don't like doing this. I can't tell which is not important and all, but these 3 are few things only I can eliminate. 145, 146 you put it as B. Punishment anyway you are remembering, but B. Powers and duties, it depends. On the fraud reporting, government, 6 enquiries now I will put it as A. Remuneration, put it as B. Come to foreign companies. 379 is most important, A plus. Application of act to foreign company. Earlier there is something called electronic mode. It includes what which is foreign company, which foreign company has to follow full provisions of Companies Act, not less than 51%. We also spent a lot of time in that section only. So A plus, very important. 380 also A plus. Appointment of authorized representative and appoint an FC1 within 30 days. All of that. Okay. Then here IDR C. This is C. Punishment you put it as A. 393 you put it as B. Accounts of company B, display of name is B, service and all is B. 384 is C, this is C, interpretation C, B, provision as to expert consent you can put it as B, registration of prospectus B. Okay, that's it, done guys. Okay, fine, that's it guys. So done. Thank you. Fine. Oh, super. Okay, thank you guys. Super. Okay.